Good morning, good morning, good morning, law nerds. It is Tuesday. It's time for Coffee and Cursey Words. A lot has happened this morning since I woke up, and we're going to talk about, well, some of it because I've got coffee. I've got Cursey Words, probably not as many as Sam Bankman-Fried. Probably a lot more Cursey Words from him this morning. We're going to go over the 3 documents against him, and then we're going to get into covering last week's hearing on the Murdaugh pretrial motions with my breakdown live. So it'll be me going through that hearing with you. If you've already watched it, hopefully the explanation helps, and we're going to be going through that. But with this wild turn of events that started last night, we couldn't leave it alone. I want to look at these indictments, so we're going to have to. We're going to have to take a look at those this morning. And then I know a friend of the channel, Law and Lumber, is going to be doing a deeper dive into this. He's been covering this case a lot and the bankruptcy of FTX. If you are like SBF, FTX, WTF, we'll do a brief explainer. We're not going to get deep into like the ins and outs of crypto. We're going to get into the ins and outs of criminal prosecution and fraud. That's what we're going to talk about. If you're in the replay crew, love you. Link down below, and a quick note. We are doing a giveaway today. I will tell you when. There will be a keyword that you will enter to enter into the giveaway. We will do it live. We are going to give away 3 of these. I will show you what's in them in just a minute. 3 of these today. I'm going to give away a few more across social media. I'll tell you about that. So we are going to be giving away, these were the 200K celebration boxes that, well, we were going to sell, but then the members bought them all. I promised the members a pre-sale. It's one of the membership perks of the top tier levels is exclusive merch, and they sold out in like 20 minutes. So we reserved a few for giveaways to the rest of the community. I know not everyone can be a member. If you are, there will be a live stream tomorrow for you, tomorrow night. But I want to make sure that we can include the community. So this giveaway box is really fun. I'm not going to show you everything that's in it, but I will show you one of my favorite things that's in it. Some of you might have seen these around social media. We anticipated these boxes at 200K before Debt Be Heard, and then it got crazy. So we've got the tumbler in the box, which is really, really fun. And then one of my favorite things in this box is the stress squishy gavel that now I'm going to start using. I will start using the stress squishy gavel. There's a few other things in here that I'm really excited about. I love it. And then a little letter from me. It is a very fun box. The team put a lot of work into putting these together. And don't worry, we're in production on a 500K box because that happened. But the members who were there last night, the giveaway was so fun. And you know what? I see a question from Marlene. Hold on, I was trying to get it. I saw a question from Marlene. Where did it go? Where did it go? My team told me we were going to do US only, and I decided that I was going to do international because we can ship it. Look, it might not get there in time, but we have an international audience, so we are going to just ship it. Because you know what? I appreciate you guys so much, and we have so much of an audience, particularly in Canada, Australia, the UK, but we have to. So, Whitney, don't feel bad. Sometimes when you see something fall apart and you're like, why hasn't anybody been arrested? And then they get arrested, you're like, oh, fantastic. So don't tell my team. They're just going to know when the shipping addresses hit. They're going to be like, what's happening? Don't worry, team. It's fine. It's fine. It's fine. It's going to be fine. They might not get there in time. We'll deal with it. We can make it happen. We had some international shipping hiccups, so it might take a little bit longer, but I'm very excited about the unicorn tumbler. These are custom made. They are great. They are from the same manufacturer that does the Starbucks tumblers. They are hand wash only, all the things. Let's get into today's topics. We'll get into this giveaway in a little bit. Today we are doing 3. Today we are doing 3 of the giveaways. So yay. So yay. All right. Let us go. Let us go. Let us go. I saw somebody in the chat. Amelie, our Law Nerd shop ships to South Korea. We will absolutely ship to South Korea. There are only a few places that U.S. shipping carriers won't ship to. South Korea is not one of them. All righty. It's time to roll the intro. I want to look at these indictments so bad. It's a first look. I want to. There are three things. We need to look at all three things. So we need to get started because otherwise we're not going to get through all of this Murdaugh hearing. So let's get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Okay, I lied. We're not getting directly into the indictment because there's something else that we need to talk about. If you follow me or anyone really in the legal commentary law to be space, you might have seen this story. I'm not crying, you're crying, we're all fine. But there is a YouTube channel called Crack in the Box. Crack in the Box is a young man who is, well, he's had two heart transplants, but is now on palliative care. However, he received a Make-A-Wish video from Johnny Depp. He also asked to be a YouTube star and get his own silver play button. So if you have not gone over to subscribe to Corey at Crack in the Box yet to help make this holiday dream come true, this wish come true, they have already hit 118,000 subs. When I shared this out yesterday on Twitter, Corey had just celebrated like 1,000 subs, and then was it like 10,000, and then 20, and then overnight, and throughout the day yesterday, Corey went from 1,000 subs 4 days ago to 118,000 subs to make a kiddo's dream come true. It is such a fantastic way for community to come together and support. So if you can, I will make sure that the link is down below so that you have it. But if you can, go check out the videos, like them, take a look at Johnny Depp as Jack Sparrow making a Make-A-Wish message, and celebrate these milestones with Corey and his family. It is such a big deal as they are spending their holidays together because that's what they get to do. So I'm blown away by the power of community constantly. I love when a community can come together. We can't always fix everything that's going on in the world, but I love to see a community say, you know what, this was a goal, and just by the power of simply being here on this platform, we were able to make that goal happen. So 118,000 subs. Let's keep going and see how much. I reached out to those I know at YouTube and I'm like, can somebody expedite a play button now? Expedite a play button now. I'm sure they can. So I'm very, very excited to see where this community can help Corey and his family. We're already at 119,000. So thank you guys. Again, you can't always make everything happen. You can't always fix the things that are going on, but being able to simply subscribe to a channel and make a dream come true is a huge thing. So even though it feels like something little, it's a little thing that means a lot. Thank you, Law Nerd community. Thank you to all of the creators across the internet, the ones who brought this to my attention. The first I saw it, I got a message from Legal Bites from Alita, and Alita was like, have you seen this? And I was like, no, let's go. And everybody just came together and shared it out, got a lot of attention for it to help make this happen. So thank you. I can't imagine what this family is going through, but what I can say is the thrill of having this to focus on has to be a blessing. It just has to be a blessing to be able to just focus on YouTube, focus on making videos with the community, focus on watching the numbers, and it gives something really, really positive to focus on during this time. So I'm not crying, you're crying. But I'm just blown away. I'm blown away by what this community can do, what this community continues to do, what you've done on charity streams, on Alita's channel, on Runkle's channel, on this channel. It's just amazing, the power of community. So thank you. And we saw that. We've seen that with other YouTubers hitting massive milestones before we lost them. And it's just a really, really big deal. So thank you. I'm so excited. I'm so happy. I'm also so emotional. It's just such a gift. It's just such a gift. So I can't wait till they get that play button in their hands from YouTube. And yeah, community, you're amazing, law nerds. Thank you. Thank you. Should we have a palate cleanser of rich people getting arrested in the Bahamas? Is that our palate cleanser? That might be our palate cleanser. I'm sorry, that's our palate cleanser. So I try to rein it in, but I'm just blown. I truly, truly am blown away. And thank you. Thank you. Thank you. So all of you, it is time for quick bits. Quick bits. All right, we are starting out over at, well, no, we're not. Where'd my link go? In just a moment, we're starting out with the FTX story. This is all we're doing in quick bits today, but there is a lot to cover. So with that, I love that we are just like, okay. We're all just reining it in this morning, and we're going to talk about people getting arrested in the Bahamas. Let's talk about that. The fact that that's the palate cleanser today. Look, man, the amount of money people lost in this is stunning. Shout out to creators again. Law and Lumber has been covering this. CoffeeZilla has been covering this. CoffeeZilla, look, man, I know people are always looking for investigative journalists that aren't mainstream media. CoffeeZilla, if you're not watching Coffee's channel, you might not be into crypto. The crypto bro space might make you be like, bleh. I get it. But he has uncovered some staggering crypto frauds, crypto scams, crypto anomalies, and really breaks it down in a way that I can understand. The crypto space is not where I put a lot of my mental energy. I don't understand. I truly don't. I mean, I get the theory. I understand blockchain. I think blockchain has a lot of good uses. But when these things and like creator coins break up and they're like, we're just going to like make it a funny name and then it's a currency, I have questions. So there are creators who cover this really, really well. I like covering the law side of it. That's the side I'll cover. Law and Lumber has a tremendous background in bankruptcy and is covering this cluster F of a bankruptcy from FTX. At the end of the day, lots of people lost lots of money, and there's a connection. I know that Law and Lumber talked about it. I think that Hogue also talked about it, with FTX parents being like very high level attorneys, like college professor attorneys in the tax world. It's so freaking weird. There's so much that's weird here, so much more that's going to come out in this story. But let's talk about SBF, Sam Bankman-Fried. I know everybody was calling him Fried. I'm going with Fried. Some of you are going to go with fraud. Mods, if people call him Sam Bankman-Fried, I don't know if I'd consider that name calling. Is that terrible? That is terrible. No, we're just going to go with SBF, and in our head, we'll know exactly what it is. SBF, arrested in the Bahamas over FTX. All the acronyms today. Disgraced former cryptocurrency billionaire. Yeah, what is his net worth now? And FTX founder Sam SBF was arrested Monday in the Bahamas at the request of U.S. prosecutors, according to officials in both governments. The U.S. attorney for the Southern District of New York. Hey, Southern District of New York. You know what cases they like the best? Fraud. SDNY. Fraud. They do fraud. That's what they do, fraud. So the U.S. attorney, Damon Williams. Oh, we need to get back. We need to get back to the crypto couple that was like money laundering massive amounts of crypto. We need to get back to that. KK Girl said very sus the night before he was set to testify before Congress. It is sus, but also, was he hopping a private plane to DC? Like, if it was literally the night before he was supposed to testify at Congress and he was still in the Bahamas, was he actually going? Like, was he really going to get on a plane or not? I have questions. We expect to move to unseal the indictment in the morning, and we'll have more to say at that time. I have the indictment. There's probably a press release. We'll go find it. The Bahamian office of the Attorney General confirmed Bankman-Fried's arrest in a separate statement. Authorities in the country where cryptocurrency exchange FTX is headquartered said they will extradite the beleaguered former CEO promptly once a formal request is made. Well, now it's unsealed. They will probably move to extradite him, and I'm sure he will be extradited quickly. The Bahamas and the United States have a shared interest in holding accountable all individuals associated with FTC who may have betrayed the public trust and broken the law, said Bahamian Prime Minister Philip Davis. While the United States is pursuing criminal charges against SBF individually, the Bahamas will continue its own regulatory and criminal investigations into the collapse of FTX because they were like running it out of a house in the Bahamas. The U.S. Securities and Exchange Commission, the SEC, also had Bankman-Fried in its sights with Gruber. What? Did I say that right? Grubier? Grell? This sounds like a name from a Harry Potter book and I'm living. It sounds like a professor in Harry Potter, and I'm living for it. Thank you, SEC Exchange Commissioner. The director of the SEC's enforcement division said Monday the agency had separately authorized charges against the FTX founder. We will go through that. Grual said the changes related to securities law violations will be filed publicly on Tuesday. We'll have those. Bankman-Fried's arrest comes just a month after FTX's spectacular collapse, which has led to multiple insolvency cases filed in 3 jurisdictions. It's also collapsed multiple other businesses. FTX Trading Ltd. commenced its Chapter 11 case in Delaware on November 11th after more than a week of turmoil that saw its value drop from $32 billion down to effectively zero. Isn't there still a place in Florida, like in Miami? Isn't there still a stadium named FTX? Like, hasn't FTX been promoted like in Super Bowl commercials by football players, race car drivers, on race cars, on stadiums, tours, like all of it? They were supposed to, or they tried to work with Taylor Swift, and Tay-Tay said no, a tie into what we were going to talk about today, but aren't. The filing came after BF resigned in the early morning hours of November 11th and was replaced by John J. Ray. That didn't fix it because then he went all over Twitter and started talking to literally fucking everyone. So thank you so much. Pronounced Grubier Graywall. Thank you. I cannot with consonants in places. The dyslexia makes it very hard to pronounce names. So thank you very much. Gruber Graywall. I can get that. In written testimony, I just love the alliteration of the GGs. I love it. I love it. Joni Nix asked, wasn't the Girardi accountant arrested in the Bahamas? Yes. Yes, the Bahamas has different laws, and people will do things in the cruise ships will flag under the Bahamas for more favorable laws. People will move money to the Bahamas for more favorable laws. Yes. Yes, it's not a surprise. And you can get Bahamian residency if you purchase a house over a certain amount. So I'm sure that SBF is probably a maybe dual citizen, but also a citizen of the Bahamas. I wouldn't be surprised. In written testimony to the House Financial Services Committee, Ray said FTX's previous leadership lacked the experience and sophistication necessary to run a company of its size. Can we stop looking at people and being like, they were just young. They said they could do it. They told everyone they could do it, and they took everybody's money. So oopsie is not what it's going to work for me. Oopsie's not going to work for me. No. And that there's a painstaking effort underway to account for all the exchange's digital assets. Ray, who will testify live before the committee Tuesday morning, so the new CEO is testifying, said in his written testimony that since taking over the company, his priorities have been to trace FTX's assets. Where'd the money go? Where'd the money go? And install robust financial controls in an effort to maximize recoveries for the enterprise's consumers. BF was also scheduled to testify Tuesday before the committee as part of the investigation into the exchange's collapse, taking to Twitter on Friday in response to a tweet from committee chair Rep. Maxine Walters in California. He said he was willing to testify. This is all playing out on Twitter. It's so weird. Dave wisely said, oopsie doodle is not a legal defense. Correct. And everybody trusted him with their money. Why? I don't know. Maybe it's okay to be like, No. Everybody wants a wonderkind. No. No, sometimes you just need experience and age. I still do not have access to much of my data, professional or personal. Good. So there is a limit to what I will be able to say, and I won't be as helpful as I'd like. But as the committee still thinks I'd be useful, I'd be willing to testify on the 13th. Well, he's, maybe they will be able to get him. Waters said in a statement late Monday that the hearing will go on with or without the former CEO. Although Mr. BF must be held accountable, the American public deserves to hear directly from SBF about the action. Well, they've heard on Twitter. Maxine, he's been all over Twitter. Go watch CoffeeZilla's channel. He's been chatting on Twitter a lot. Rob in the chat says his written testimony was made public. He doubled down on the whoopsie doodle and played victim because he went from $10 billion to $100,000. Oh, this is the fucking equivalent of all of Elizabeth Holmes's family saying, but Your Honor, she's been punished enough. She lost her stocks. And I know that people were on medications they shouldn't have been, and people were told they were losing pregnancies when they weren't. People were told that they had cancer when they didn't. I know that people suffered, but she lost her stocks. And that's been really painful enough. Fuck off with all of this. He went from a $10 billion valuation of monopoly money. He went from a $10 billion valuation to $100,000. Good luck paying for your attorneys, SBF. I'm curious as who's going to be representing him and where that money's going to be coming from. Didn't they move assets, like multi-millions of dollars of assets, of FTX's assets, into his parents' name, into a home? Miss me with, I used to be worth $10 billion. SBF posted a long thread on Twitter to explain himself and promised to find everyone's money. He shouldn't have lost it in the first place. It's not like it walked off on its own. Y'all feel bad for him. Feel bad for him. He used to be somebody. Ugh. Sorry. Okay. Well, I'm disappointed we will not be able to hear from Mr. Bankman-Fried tomorrow. We remain committed to getting to the bottom of what happened. Yeah, so do the prosecutors. And the committee looks forward to beginning our investigation by hearing Mr. John Ray III tomorrow. That's probably better. He doesn't have a conflict of interest. He's probably not willing, he's probably not the one going to jail. The former CEO also appears to have resisted appearing before the U.S. Senate Committee on Banking, Housing, and Urban Affairs. In a joint statement Monday, the senators, who are the committee chairman and ranking member, respectively, said BF's counsel has refused to accept service of subpoena. We have offered SBF 2 different dates for providing testimony before Senate Banking, Housing, and Urban Affairs Committee, and we are willing to accommodate virtual testimony. He has declined in an unprecedented abdication of accountability. Ooh, I like that turn of phrase. I appreciate lawmakers. Look, there's one thing politicians are good at. It's generally talking. I really appreciate the turn of phrase for the abdication of accountability. Crystal, Accio missing money. Yeah, if only it were that easy. I like that. Yes, abdication of accountability. Given that BF's counsel has stated they are unwilling to accept service as subpoena, we will continue to work to have him appear before the committee. He owes the American people an explanation. Well, he thought he was giving it on Twitter. He thought that's what he was doing. Here's what it seems like to me. This is my speculation. This is what it seems like happened. Their company seems like they had money that was supposed to be in different accounts, like Tom Girardi. Different accounts. And then they put it all in one place and we're just glad handing it and just grabbing money out of the big pot of money going, money's never going to run out. Money, money, money. And then whatever they were thinking they were going to double down on or invest on or make money on did not go well. And the money was gone because people were pulling it back out because there wasn't enough to begin with and there wasn't enough to cover and it wasn't secure. It wasn't like you put money People thought they were putting money into like a savings account. This is how CoffeeZilla was explaining it. They thought they were putting money into like a savings account with the FTX exchange, and the money was just going to be there. And then if it grew, if it gained interest, like it can in any bank account, it grew, but it was safe. It was in more like a savings account. It wasn't in like an investment account. And they put all the money together, savings account, investment account, whatever. And so those in the risky investment accounts were able to pull money out. But if there wasn't enough money that was theirs, they were able to pull it out of your savings account because they put all the money in one big pile of digital numbers and fakeness. So I think they should have CoffeeZilla. I saw a couple comments in the chat about, will CoffeeZilla go to Congress? I think they should absolutely ask CoffeeZilla to go testify at Congress. You know why? Because I don't think most of the members of Congress or their aides know exactly what to ask. And I think CoffeeZilla would be more than helpful to talk about crypto regulation and what's going wrong in the space and where people are finding loopholes to do this stuff. Because I still have questions about whether FTX as an exchange is regulated by the SEC. And I'm sure his attorneys are going to argue that it's not regulated by the SEC. So BF has been hit with a wave of lawsuits and investigations in the wake of his company's collapse. I'm not surprised. Look at my shocked face. On Thursday, nonprofit Citizens for Responsibility and Ethics in Washington accused BF of violating federal election laws for failing to disclose so-called dark money campaign contributions to Republican political candidates in a complaint filed with the FEC. All the three-letter words are coming out. Last month, the Texas State Securities Board said it's looking into whether Bankman-Fried broke securities law by selling unregistered securities in the Lone Star State. I'm sure every state will jump in on that. The board had set a hearing for February 2nd to determine whether he should be fined and ordered to refund investors. There's no money, so you can order it. Not going to happen. This case is going to make us have a large conversation about what it is and is not regulated, what is and is not a security. But here's what's going to also come out of this, and this is the part I'm most interested to cover. All of the people... Do you remember the Kim Kardashian case with the cryptocurrency? And the rule that she violated with the Securities and Exchange Commission is that if you are promoting a financial instrument like she was, when you promote it at the same time, you are required to disclose how much they pay you. Hi, I'm Emily. I'm promoting this Stanley Cup. They've paid me fucking nothing. But when you're promoting a financial token, you are required to disclose exactly how much. How many people promoted FTX and did not disclose exactly how much they were paid? Because my guess is going to be a lot. And it will be very interesting if they're taking the FTX exchange separate from the coin and saying this exchange is a security in the way that it was being run. A lot of people needed to disclose a lot of sponsorships and needed to disclose the exact amount of money they were paid. Hi, I'm a football player. I think crypto is great. To the moon, put your money here. And then it needs to disclose, I was paid $10 million for this spot or whatever it is. I think that's going to be the second round of lawsuits. There's already lawsuits. Oh, I know there are. But I think this is not just private lawsuits, but the lawsuits, the regulatory action coming from the SEC as well. So Tom Brady, Gisele Bundchen, Kevin O'Leary. Yeah, we're gonna see the SEC actions as well. So, and it seems that SBF and FTX were not just putting money into one side of the political spectrum. They were donating money to both, which a lot of corporations do. BF is also facing a pair of investor lawsuits in California and Florida, accusing him of scheming. That doesn't say scamming. My brain just filled it in. Scheming to deceive investors and offer them unregistered securities. The complaints, which also name as defendants the Golden State Warriors basketball team and a host of celebrities and athletes who endorsed the now bankrupt crypto exchange, allege that investors relied on misrepresentations in purchasing a yield-bearing account with FTC. Is it a security or not is going to be a big question. Let's get to these filings. I'm going to pull, and maybe we'll just do a like influencer court of like all of the people who promoted this and all of those promotion lawsuits and talk about the questions of the promotion lawsuits. Troy said, can the people who promoted it go to prison? No, it's a penalty. It's a civil penalty. There's generally not criminal penalties for those things. Those laws don't exist. So no, not prison. Yes, they can lose a lot of money. Did Brady disclose how much he was paid? I don't know. That's why these are why I'm asking these are my questions. This is why I'm asking the questions. So, and again, it is the job of the lawyer. Like, is it Tom Brady's job to know, oh, is this FTX exchange considered a security or not? Is it his job to know that? No, it's his lawyer's jobs to know that. It's the agent's jobs to know that. But it's people have to know this. If you're taking that much money, do I have to disclose it? Yes. But there's an argument that it's not a security if it's a crypto exchange. And that's where these laws are going to fight. Jojo said Brady had like 45 million, Giselle like 2 million, Kevin O'Leary was paid 18 million. We'll just go over the lawsuits on another day. Question, with all the donations, you wonder how much he knew beforehand, and was he doing it to protect himself? I mean, I'm way cynical. I think he was probably doing it so that maybe those in government would be inclined to say, a crypto exchange is of course not a security. You don't need to be regulated. Not that way. Let's look at these. Should we go with the big one first? Go with the indictment first? I think we go with the indictment first. Indictment, we have 3. So here's what we're doing. We're going to do the indictment. We're going to do our first part of the giveaway. Then we're going to look at the SEC complaint, then the CFTC complaint. Then we're going to start going to the live hearing. It's going to be just a long show today. That's just what's happening. It's what's happening. It's every day, bro. Okay. Oh, crypto bros. The fall of the crypto bros. Hate to see it. Being sarcastic. All right. Let's see. My kid is texting me that my friends are listening to your Constitution reading on the ASMR channel. Well, I do it well, buddy. I'm going to have to text my kid back. That's hilarious. He always is. It's always weird to him when his friends find me talking about something on the internet. All right. United States of America versus Samuel Bankman-Fried, aka SBF. I love that they just respected the initials. You know, there's a part of me that's like, do we just go to EDB officially all the time? Do we just do that? Should we just do that? Count 1, conspiracy to commit wire fraud. This is what I asked on Twitter. How many counts of wire fraud? Let's see. I want to know what they allege. Ooh, this is a little bit, well, yeah, it's kind of complainty. Someone's going to ask for a bill of particulars. I want to see it. Do it. From at least in or about October, or sorry, that doesn't say October, that says 2019, up into including about November 2022 in the Southern District of New York and elsewhere, SBF, the defendant, and others known and unknown, willfully and knowingly did combine, conspire, confederate, and agree together with one another to commit wire fraud. There's your conspiracy allegations, conspiracy to commit wire fraud. It was a part and object of the conspiracy that SBF, the defendant, and others known and unknown, knowingly having devised and intending to devise a scheme and artifice to defraud and for obtaining money and property by means of false and fraudulent pretenses, lied. They lied about what they were doing with your money. They did it through the wires, which is anything on social media. They didn't give us much more detail. To wit, SBF agreed with others to defraud customers of FTX.com by misappropriating those customers' deposits and using those deposits to pay expenses and debts of Alameda Research, SBF's proprietary crypto hedge fund, and to make investments. So this is like a hedge fund collapse that was funded by the FTX exchange, and that's not what it should have been. So here's the conspiracy to commit wire fraud. Anything can be the wires. I wonder if they're going to go with I wonder if they're going to argue at some point that his behavior on Twitter leading up to this was lulling behavior, trying to keep people's money in there so that he could perpetrate the fraud longer. I just wonder. Count 2, wire fraud. Same dates, 2019 up to November 2022, SBF and other defendants. The defendant knowingly having devised and intending to devise a scheme to defraud, did so by use of the wires, which is literally anything on the internet, anything at this point. Wire fraud has gotten very broad. Engaged in a scheme to defraud customers of FTX.com by misappropriating their deposits and using those deposits to pay expenses and debts of Alameda Research. So this is what we were talking about. There was a crypto hedge fund that was much riskier. Then there were like all the savings accounts that were not as risky. They put all the money in a big pot and let anybody grab it, and they grabbed it. Conspiracy to commit wire fraud on lenders, count 3. June 2022 up to November 2022, SBF willfully and knowingly did combine, conspire, all the conspiracy language. The object of the conspiracy being that the defendant and others, knowingly having devised and intending to devise a scheme to defraud, did what? Use the wires to used the wires to defraud lenders defraud lenders to Alameda Research, BF's proprietary crypto hedge fund, by providing false and misleading information to those lenders regarding the financial condition. So said the company was not going under, for example, when in fact it was. So lying to investors, no, it's fine, it's stable, it's good, it's funded. Count 4, there must be something specific that they have because these dates are much more specific, June 2022 to November 2022. All right, count 4, wire fraud on lenders. This is the same dates, 2019 through November 2022. All the fraud language, using the wires to do what? Engaged in a scheme to defraud lenders to Alameda Research, the hedge fund, by false and misleading info to those lenders regarding the financial condition. So fraud on lenders, conspiracy to commit fraud on lenders. So the conspiracy is the agreement with others, the fraud's doing the thing. Conspiracy to commit commodities fraud. I'm surprised there aren't more counts of wire fraud. 2019 to November 2022, in jurisdiction, SBF with others, there's the conspiracy. Artifice to defraud over the wires, there's the thing. Did what? And then here's the language of the commodities fraud. Let's see. Under Title 17, by A, using and employing and attempting to use and employ a manipulative device, scheme, or artifice to defraud, attempting to make an untrue or misleading statement of a material fact and omitting to state a material fact necessary in order to make the statements not untrue. So lying. Engaging and attempting to engage in an act, practice, or course of business which operated and would operate as a fraud and deceit upon a person in violation of Title VII of the U.S. Code. SBF with others, or agreed with others to defraud customers of FTX.com trading or intended to trade swaps by misappropriating those customers' deposits and using those deposits to pay expenses and debts of Alameda Research, SBF's proprietary crypto hedge fund. So again, taking money from one place, putting it to the other place. In furtherance of the conspiracy, acting with others. Oh, here's the overt act in the conspiracy. In furtherance of the conspiracy and to effect the illegal objection thereof, the following overt act, among others, was committed in the Southern District of New York in or about June 2022. SBF and others misappropriated FTX's consumer deposits in order to satisfy loan obligations owed by Alameda Research. So again, this. So count 6. From at least in or about May 2022 up to and including in or about November 2022 in the Southern District of New York and elsewhere, SBF, the defendant, willfully, what is this count? Conspiracy to commit securities fraud. So this was commodities fraud. This is just defining the instruments differently. Let's see. Conspiracy to commit securities fraud. Same May 2022 to November 2022. SBF and others. Let's see. Use the instrumentalities, so they're defining it as a security and then talking about the fraud in the exchange of the security. Scheme to defraud investors in FTX by providing false and misleading information to those investors regarding FTX's financial condition. In furtherance of the conspiracy and an effort and illegal object thereof, the following overt act, amongst others, was committed in the Southern District, of New York and elsewhere on or about September 18th, 2022. SBF caused an email to be sent to an FTX investor in New York that contained materially false information about FTX's financial condition. So that's the overt act. Let's see, count 7, conspiracy to commit money laundering on or about 2020 into and including November 2022. Let's see where the overt acts is with the money laundering. It was a further part and object of the conspiracy that SBF, the defendant, and others attempt to engage in a monetary transaction in criminally derived property of a value greater than $10,000, and that it was derived from specific unlawful activity, to wit, the wire fraud alleged in count 2 of this indictment. So money laundering of the wire fraud proceeds. Count 8, conspiracy to defraud the United States and violate the campaign finance laws. Oh, well then, there we go. 2020, including November 2022 in the Southern District of New York, SBF. Then we have the conspiracy language. Object of the conspiracy, the defendant and others would and did defraud the United States and an agency thereof by impairing, obstructing, and defeating the lawful functions of a department or agency of the United States through deceit and dishonest means, to wit, the Federal Election Commission, the FEC, not the FCC, not the FTC, but the FEC. Got to be 3 letters. The FEC's function to administer federal laws concerning source and amount restrictions in federal elections, including prohibitions applicable to corporate contributions and conduit contributions. It was a further part and object of the conspiracy that SBF and others would and did knowingly and willfully make contributions to candidates for federal office, joint fundraising committees, and independent expenditures committees in the names of other persons aggregating more than $25,000 in a calendar year. Oh, coffee. My need for coffee. It was further part and object of the conspiracy that SBF, the defendant, and others known and unknown would and did knowingly and willfully make contributions to candidates for federal office exceeding $25,000 or more in a calendar year. It's funny, Tom Girardi donated lots of money to politicians, never got investigated. Weird. In furtherance of conspiracy and to effect the illegal objectives thereof, this is the following overt act. In or about 2022, SBF, the defendant, agreed to and did make corporate contributions to candidates and committees in the Southern District of New York that were reported in the name of another person. So it sounds like they were hiding the source of funds. Forfeiture allegations. We gonna take your shit. That's the forfeiture. Anything you have that is derived from these funds or could be derived from these funds or commingled with these funds, we're going to just take. And there's the indictment. So this is, and there's the 4-person. So this was done at grand jury, hence the indictment. Let's look at the other 2 agencies and what they have to say. Hold on. Let me look one more place. We're going to do a giveaway in just a second. And I'm going to let you guys join the giveaway. Well, let me pull it up real quick. We are going to join the giveaway. The text is going to be, here's what you need to text to enter. This is why I take questions at the end, because the questions are going to get lost. So if you have questions, wait till we get to questions, because they are going to get lost. So we are going to do the giveaway for the 200K box for the first one. So you can get your own little law nerd cuppy poo, your own little gavelly do, and others. So we are going to use hashtag. Should we just use SBF? Yes, we should. We're going to just use hashtag SBF in the chat. So we're going to let all of those entries come in while I go take a look and see if we have a press release, which I'm sure we do, because that's where you always get the T from the United States. Let's see, from the AUSAs. So let me pull that up. Southern District of New York. Thank you guys for entering. I put it in lowercase, so it shouldn't be case sensitive, but just in case, do it in lowercase because, I don't want Nightbot to swoop it on you, and because that would be very unfortunate. So put it in lowercase and let us get to the press release. A press conference at 2. Well, I guess there's a press conference at 2. Could you just give us a press? There will be a press conference today at 2 p.m. to announce the indictment of Sam Bankman-Fried, founder of now defunct. The press conference will be live streamed on Facebook. That is, they're in New York, so I'm assuming that's 2 p.m. Eastern. So 1 p.m. our time. They're streaming it live on Facebook. They announced on Twitter. So I don't see a press release yet because they're going to do a press conference. All right. I guess we'll look for the press release on Thursday because that's not happening. We have almost 10,000 people in the chat and we have 1,000 entries. So go ahead and get those entries in if you want to enter to win. And we are going to roll this giveaway in just a moment. I'm going to let those entries keep coming in and then we will roll it. Let's go look as those entries are coming in at the CFTC complaint, and then we'll go to the SEC complaint. This one, why is it 40 pages long? We can't go through this whole thing. It's supposed to be quick. Oh, good God. This is much meatier than I thought. All right, we're going to look at the charges, and then we're going to move on. Maybe we'll cover this in depth on Thursday. Others will have covered it by then, but that's okay. Complaint for injunctive and other equitable relief for civil monetary penalties under the Commodities Exchange and Commission's regulations. Let's just go through the summary. SBF co-founded Alameda Research, a digital asset trading and investment firm in Berkeley, California, 2017. In May 2019, he and others launched FTX Trading, BDA. Is that supposed to be DBA? Probably. FTX.com, and various subsidiaries, affiliates, and related entities, collectively doing business as FTX.com or simply FTX, a centralized digital asset exchange. These parties are collectively referred to as defendants. Alameda and FTX were large and well-known players in the digital asset industry. SBF, their young, high-profile leader. What else does that sound like? At its peak, the daily trading volume of FTX was over 20 billion. Daily trading volume of 20 billion. It had garnered a $32 billion valuation. FTX had prominent paid sponsors, including naming rights to a professional sports arena in Miami, celebrity endorsements, and a 2022 Super Bowl commercial that touted FTX as, quote, the safest and easiest way to buy and sell crypto. I actually remember those Super Bowl ads because I was like, we're shilling crypto on the Super Bowl? That's what's happening now? It was surprising to me. I was like, where are my Doritos commercials? Like, what? I'm used to food commercials, but no, the crypto, they had QR codes on the screen for all of them. It was crazy. On November 11th, 2022, SBF's empire abruptly collapsed. It's like the House of Cards caught up with it. FTX customers and the world at large discovered that FTX, through its sister company Alameda, had been surreptitiously siphoning off customer funds for its own use, and over $8 billion in customer deposits were now missing. $8 billion. That says $8 billion with a B. $8 billion in customer deposits were missing. Where the fuck does $8 billion go? Beginning no later than May 2019 and continuing through at least November 11th, 2022, SBF owned, operated, and controlled FTX and its subsidiaries. He also owned, operated, and controlled Alameda. Throughout the relevant period, Alameda operated as a market maker on FTX.com, providing liquidity to its various digital assets. Oh my. All right, let's see what the charges are real quick on this complaint. And we will dive into this more fulsomely, as my friend Hogue would say, at another time. Where are our counts? We know all the money was put in a big pot and everybody grabbed it and $8 billion is gone. That's what your allegations are. But where are your... We've got conversations of executives in this complaint. That's going to be spicy. We've got tweets of SBF. November 7th, 2022. A competitor is trying to go after us with false rumors. FTX is fine. Assets are fine. Details. FTX has enough to cover all client holdings. When the things you say on Twitter come back to bite you, oh my, oh my. In direct contradiction of an internal series of events on November 7th in public statements and various Twitter messages, SBF and others acting on behalf of FTX continued to portray the shortfall that was causing customers to be unable to withdraw their funds as a mere liquidity problem. Oh no, the money was gone, like Girardi style gone. FTX has enough to cover all client holdings. We don't invest client assets even in treasuries. Mr. SBF, the prosecutors are going to love showing your tweets to the jury. This is going to be blown up on a massive screen in front of the jury, and they are going to have a dramatic pointer and go, ha! You said we don't invest client assets even in treasuries. We have been processing all withdrawals and will continue to be. Were you lying? Oh, this is spicy. Look, man, the commodity exchange has all of the tea. This is going to need a whole episode. Count 1, fraud. Shock Pikachu face. Count 2, fraudulent misstatements of material fact and material omissions. Different section of fraud. Relief requested. Well, you want the money back. The commission requests that the court, pursuant to its equitable powers, enter an order finding the defendants, FTC and Alameda Research collectively and through their officers and employees violated these regulatory sections. An order of permanent injunction prohibiting defendants and any other persons or entities associated with them from engaging in the conduct described above. You can never deal with money like this again. Permanent injunction from defendants and any of their affiliates, agents, servants, employees, successors, assignees, attorneys, or any person in active concert or participation from directly or indirectly trading, entering into transactions involving commodities. This is you can never participate in this way again. Interesting stuff, because they're not going to get the money back. They're just going to block everyone involved from doing this again, which might be, which is what the regulatory agency is doing. Let's run our giveaway. Are you ready? There's 2,000 entries in our giveaway, and we are going to run it. Here's what I need to tell you. The rules of the giveaway are down below. You just have to be subscribed to the channel, and you have to enter the keyword. You have to be willing to be contacted by email. If you are the winner, you need to email help@Emily.D.Baker. It's listed in the description below if you win. You need to email help@ with your screen name and the link to your channel so that we can verify that you are you. Thank you for only the winners emailing us at help@. Though if you have any other issues with anything, help@ is our email. From the memberships to the wonky things that YouTube does to the store, help@ is our best email for that type of help. Not for Emily, please cover this. Those go to my other email because those won't get seen at help@. Well, they'll get seen. They'll get yeeted. All right, you ready? Let's go. Let's see who wins our first box, and Miguelina's going to write it down for me. Good luck, YouTubers. Good luck. Winner. Snooks Maven. Did I pronounce that properly? Congratulations. Shoot us an email at help@Emily.D.Baker. So for the next drawing that we're going to do in a little bit, we are going to change the hashtag. So don't keep entering SBF, because those will not work. We are going to do a separate one for the next drawing. Congratulations to our winner. Go ahead, and you're saying Snow Maven. I mean, that's probably right. That's probably right. That's probably right. I'm, again, dyslexic, and it makes it hard on my brain. Let's just look at what the SEC has to say. Also, you guys, Crack in the Box has over 121,000 subs. Thank you to this amazing community. Let's look at what the SEC has to say, because man, that was more than I expected from the Commodities Exchange. The Commodities Exchange Commission is just like, hey-oh. Oh, what we're doing today is this. They were on it. I can't wait to read through that and give you guys a summary. Why is my Google Drive not pulling up? Hold on. Come here, Google Drive. Hello, Google Drive. Can we do this, please, Google Drive? I want my SEC complaint so then we can move on. We're like an hour in. People are like, aren't we getting to Murdaugh? Yes, I promise. Yes, I promise. Yes, I promise. The SEC isn't going to let SBF be. He's the only one currently being sued by the SEC. I want to look at what their charges are. How long is this document? 28 pages? We need a deep dive. Do you guys want to do a deep dive? Let's put up a poll. Do we need to do a deep dive into these and the other lawsuits? Do we just need a full episode? I think we do. All right. From at least May 2019 through November 2022, SBF engaged in scheme to defraud equity investors in FTX trading, a crypto asset trading platform, of which he was the CEO and co-founder. At the same time, he was also defrauding the platform's customers. So equity investors and customers. Oh, you guys are like, yes, please. Okay, all of it. SBF raised more than $1.8 billion from investors, including U.S. investors who bought an equity stake in FTX, believing that FTX had appropriate controls and risk management measures. Unbeknownst to those investors and to FTX's trading customers, SBF was orchestrating a massive years-long fraud, diverting billions of dollars of the trading platform's customer funds for his own personal benefit to help grow his crypto empire. Through this period, SBF portrayed himself as a responsible leader of the crypto community. He touted the importance of regulation and accountability. He told the well, is he going to plead guilty then? If he's touting accountability, maybe you just plead. He told the public, including investors, that XBF was both innovative and responsible. Customers around the world believed his lies and sent billions of dollars to FTX, believing their assets were secure on the trading platform. But from the start, SBF improperly diverted customer assets to his privately held crypto hedge fund, Alameda Research, and then used those customer funds to make undisclosed venture investments, lavish real estate purchases, and large political donations. Lavish lifestyle. Lavish lifestyle. I think that's close enough for it to be bingo on lavish lifestyle. Every single one of these cases, there's a lavish lifestyle. Y'all, you know what there's not over here is a lavish lifestyle. Unless, well, that's not true. I am very deeply wealthy with my $40 Stanley Cups. I have 3. We've exceeded our lifestyle with the 3. With the 3. It's just so wild. It's just so wild to me. It's the way that people treat money like water is just, it's wild. It's just wild. I think the large political donations were to gain favor. That's apparently what rich people do. Lavish real estate purchases also in there. Bankman-Fried hid all of this from FTX's equity investors, including U.S. investors from whom he sought to raise billions of dollars in additional funds. He cast FTX as an innovative and conservative trailblazer in the crypto markets. Y'all, we're not wild like those other crypto bros. We're the responsible crypto bros. This is going to, for those that are like fans of crypto, this is going to damage crypto. Snow Maven, I can't believe I actually won. I never win anything. This totally made my day. You're having a much better day than SBF. And you have a pretty cup. He told investors and prospective investors that FTX had top-notch sophisticated automatic risk measures in place to protect customer assets, that those assets were safe and secure, and that Alameda was just another platform customer with no special privileges other than apparently access to all of your money. Well, he spent lavishly on office space and condominiums in the Bahamas and sank billions of dollars of customer funds into speculative venture investments. SBF's house of cards began to crumble. When the price of crypto assets plummeted in May 2020, Alameda's lenders demanded repayments on billions of dollars of loans, despite the fact that Alameda had, by this point, already taken billions of dollars of FTX's customer assets. Whoop, there it is. Before the crypto plummet, Alameda had already taken billions of dollars of FTX customer assets. Those assets weren't supposed to be used to back the hedge fund. It was unable to satisfy its loan obligations. This is just the crypto This is like the crypto version of the 2008 collapse, really. I mean, I could be wrong, but this is what it seems like to me. We're just pulling money from wherever, and then it's like, oh, we can't cover it. SBF directed FTX to divert billions more in customer assets to Alameda. He has gone all over Twitter saying, I didn't direct it. I hope there's an email. I hope there's an email. I want there to be an email. To ensure that Alameda maintained its lending relationships and that the money could continue to flow in from lenders and other investors. But SBF didn't stop there. Even as it was increasingly clear that Alameda and FTX could not make customers whole, SBF continued to misappropriate the funds. Through the summer of 2022, he directed hundreds of millions more in FTX customer funds to Alameda. Like he was like drunk gambling with people's money. He was like, we'll make it back. We'll make it back. We'll make it back. Just chasing. It seems like he was just chasing the collapse investments in May. Like, we'll get it. We'll get it. We'll get it. We'll get it. All the while, he continued to make misleading statements to investors about FTX's financial condition and risk management. In November 2022, faced with billions of dollars in customer withdrawal demands that they could not fulfill, SBF misled investors from whom he needed money to plug a multi-billion-dollar hole. A little bit of sass from the SEC. Get it, SEC? They're like, he's trying to put his fingers in the dam and it's not working. His brazen multi-year scheme finally came to an end when FTX Alameda and their tangled web of affiliated companies filed for bankruptcy on November 11th. This was not without sophistication. You know, a tangled web of affiliated companies is not someone who doesn't know. Violations. Engaging in the conduct set forth, he violated the Securities Exchange Act, permanently restrained and enjoined. So this is the civil actions with regard to it. So then they're going to go through all the entities and then a deeper dive into the facts. Sam Bankman-Fried and SBF is in a world of hurt with the feds, the Commodities Exchange, and Securities Exchange. And this is going to change the crypto landscape. This is going to change the way it's regulated. I don't know if these exchanges will continue to be exempt from the SEC. The SEC is saying they have authority. We're going to look into that more deeply the next time we cover this, because that's a much bigger question about how the SEC has authority. Is a crypto exchange more like a bank? Is it more like a security? How are we regulating these things? But we will have to dive into it more deeply. But what we're going to do now, as I am queuing up our coverage of the Murdaugh case, is we are going to run another giveaway. So let me do the key phrase. We're going to do a different key phrase real quick. We are just, you know what we're going to do? This one, we're going to do hashtag EDB, because why the fuck not? Lowercase. So if you start putting hashtag EDB into the chat, this will start gaining entries, and then we will roll this one soon. So let's go to our video and start talking about Murdaugh murders, because that's what's happening. All right, let me give a quick road so far. Quick road so far on Alec Murdaugh, disgraced attorney. There are so many Murdaugh cases. There are so many Murdaugh cases. In this hearing, we are going through pre-trial, and this is a first look for me too. I'm sure some of you have already seen it, but this is a pre-trial hearing before the criminal trial starts at the end of January. Murdaugh has a ton of different things going on, and I have broken that down on episodes of The Emily Show and on a playlist here on YouTube. This is just regarding the murder of his wife and son he is accused of committing. This is intertwined with the thefts of client funds. There was a suicide for hire plot where he tried to have himself offed. So it seems that insurance money, or it's alleged that insurance money, would go to his remaining son. It is such a stranger than fiction cluster of everything. It's just absolutely unbelievable. With that, we are seeing the pretrial hearing. I know we will hear some from the prosecutors about about what they believe the motive is, I think they might have some interesting evidentiary issues. And these attorneys have been kind of fiery in court. So we're going to get started with this, and then we will take a pause to run the giveaway. So let's go ahead and make this big as the judge takes the bench here in South Carolina. This is coming from Fitz News, but there were pool cameras. Fitz News, Mandy Matney and Mandy Matney's podcast, The Murdaugh Murders, has really been tremendous local coverage of this case. So while there are some major media outlets, I would love it if you guys would support the local outlets that have been on this story and have been covering it with dignity for all of the victims involved. Look, the defense is going to argue, I think, that this could have been people involved in the boating under the influence death of Mallory Beach, and that maybe people were coming after Alec Murdaugh's kid who was driving the boat for that. That boating under the influence death of Mallory Beach seems to also involve police cover-up in the investigation. It's also a mess. There are lots of civil lawsuits going on with that as well, and investigations going on with that as well, because the son that was murdered was the son at the helm of that boat. So I have seen Fitz News cover this fantastically, and same with Mandy Matney. I like following individual reporters versus just one outlet, because truthfully, haven't we all lost a lot of faith in some of these large outlets? It's just true. But Fitz News has been great, and I really appreciate good reporting. I am not a reporter. I'm just a legal commentator. Like, we just here talking about the law and shit. So let's get to the judge taking the bench, and we will roll this. We will roll for the second box of the day in just a few minutes. Please tell me if you can hear. Just
Thank you, and please be seated.
It sounds loud to me. Good.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, we're obviously here on some motions.
This is the prosecutor. This is the defense attorney over here. Court reporter, judicial assistant. No idea who this dude is. Maybe he just regulates the temperature, but I appreciate the view of the courtroom that we have. I imagine this is the view we will have throughout the trial, but the sound is good.
Motions that have been filed this week in the state versus Richard Alexander Murdaugh. He, of course, is present in the courtroom here today with his counsel,
There's Murdaugh.
and Jim Griffin, as well as Phil Barber and Maggie Fox. This, of course, is 2022 GS 15 592, 593, 594, and 595.
South Carolina has a separate indictment number for each charge, which is odd to me. Because working in Los Angeles as a district attorney, we had, like, if there was a complaint and there were 5 charges, it was 1 case number and 5 charges. They have a different number for each charge. It's odd to me. It's odd to me. In South Carolina, they're called solicitors. I have no idea. I have no idea. Wait, so he isn't representing himself? Oh, no, he's definitely not. He has a team of very high profile attorneys. How he's paying for them, I don't know. Should you guys put in your last entries? We're going to run that poll in just a minute so that you guys can get back to conversation about this without having to put EDB in the chat.
And Your Honor, over, of course, the past couple of weeks, we've had a number of motions. We were actually,
I immediately want to send the judge a cute mug.
Honor is aware, here last Friday in front of Your Honor, very briefly, where we discussed some jury questionnaire issues, and we provided to the court a general jury questionnaire for the court to do with the summons. And also at the time, I had
So what he's talking about is a jury questionnaire to be done with the summons. So when a juror gets a jury summons, they are also going to get a questionnaire. I imagine one of the first things on that questionnaire is going to be, have you heard of any of these people? Which in this area is going to be difficult because this is a very prominent and powerful family in the low country of South Carolina. So that is going to be interesting to see how those jury questionnaires come back. Let's go ahead and pull our next winner. We have 1,800 entries. So I'm giving you guys just a minute to get your last ones in. 3, 2, 1. I know there's a delay. I'm trying to accommodate the delay, and we're going to go ahead and roll this so we can get to some questions while we cover this case. All right, good luck. And our winner is Lily Koloski. Lily, congratulations. I cannot wait to send you out your very own Lawnerd 200K box. Go ahead and email us. Instructions are down below, but help@emilydbaker.com. Entries are now closed. We will run another giveaway later in the stream. We are running 3 today. Congratulations, Lily. Yay. Let's get back to Murdaugh. Yep. And so now you guys can ask some questions about Murdaugh as I try to grab them. I will try to grab some super chats too if we have a break. J. Michael Oren, thank you. We no sleep.
Discussed with Mr. Harpootlian the admissibility of any financial evidence. And so they, of course, filed a bill of particulars on Monday. And of course, we had discussed at the time us doing a response on Wednesday, which we did. And so obviously we're here to address that as well. The defense has also filed some motions as it relates to a particular forensic report. And I believe we're here to discuss things about that.
That's what I want to hear about most.
Starting out, Your Honor, with the bill of particulars, and of course we filed.
Objection, Your Honor. We filed the other motion first. I'd like.
Bro. Mr. Harpootlian, calm down. The first guy talking is the prosecutor. The second guy talking is the lead defense attorney. Harpootlian. There is no fucking need for an objection right now. The prosecutor is telling the court, hey, this is how I believe this is going down today. The prosecutor is literally saying, these are the things we are here to talk about. So this is going to get spicy. The Lauren, what did Murdaugh do? He is accused of murdering his wife and son. That's what this trial is about. What else did he do? Oh, there's so much. Is this hearing live today? This was last week. It was last Thursday. I was live doing something else. This dude is just like, yeah. I know Harpootlian has a long history of buffoonery. I try to give defense attorneys some leeway because defense attorneys have a job of zealously advocating for their client, but there is no fucking need to object while the prosecutor is saying, these are the motions we're here for today. He's not arguing. The prosecutor's not arguing. He's just saying, bro, this is what we're doing today. And I appreciated it. So let us go. Objection. It's way too soon for this shit.
To deal with the blood spatter information first, which will be briefer. And then
he objected because he wants to talk about it in a different order. I'm here for the blood spatter conversation. Let's have it. I want to know, but also, can we just give props to the camera work? Whoever's running the cameras in court, the cinematic nature of the cameras where we get this really crisp on the defense attorney and this beautiful bouquet in the rest of the courtroom. Props on the camera work. Okay, let's keep going because I don't think the blood spatter argument's going to be briefer.
then Mr. Griffin and Mr. Waters can go at it on the bill of particulars. But
We'll proceed with the motions in the order in which they were filed.
Thank you, Your Honor.
Your Honor.
And the prosecutor is now just shut up and stop talking. I don't think that the prosecutor, I think the prosecutor is tired, but I don't think the prosecutor was asking for it to go in a different order.
We filed a motion basically to have this court have an evidentiary hearing on the so-called blood spatter evidence. And I want to walk the court through what we've pieced together.
Was the prosecutor done? No.
Concerning how this was done. And let me say this.
Of course, I read your motion in which you
we detailed that.
put in, let's see, how many pages is this? 11 pages of detailing.
Yes, sir. I think it's important, though.
The So the defense attorney says, I want to detail this. And the judge is like, you've had 11 pages to detail it. This judge is going to be my favorite. This judge is taking none of the shit. And I love, and it's delivered with that South Carolina accent that is just a little deeper than like a Virginia accent. And I love it. I'm here for all of this. I'm here for all of this. Let's see. Isn't he also accused or suspected of killing the maid? You know what? I'm going to save this for questions. They have exhumed the kind of house manager, housekeeper, and nanny that died on their property to investigate it more. But the charges related to that case is that he was stealing money from her sons who were in charge of the estate. That's separate than this pending murder case. There's a lot of cases.
Because when I asked for an evidentiary hearing, I want to emphasize a couple things.
All right.
For the cameras. He left that out, for the cameras.
And I'm not going to walk you through the scientific tests that were conducted. What we do know is this.
Tell me what we know.
That on the night of the murder,
That was my fault.
they took from Mr. Murdaugh his shirt, his shorts, and his shoes. They ran a series of tests on those items.
As they do.
And found a preliminary test indicated the presence of blood, and they cut out pieces and did DNA testing on those.
As they do.
There is some of the area which would become relevant in this blood spatter. It is clear, two things are clear. One is that one of those spots of blood spatter was negative for Paul Murdaugh's DNA. Number two, the test run by SWED, which we did not get until a couple, 3 weeks ago.
Three weeks.
Indicated no presence of blood.
That's a
of
problem.
human blood, which, if you're going to have somebody testify that there's blood spatter, I think part of that is there needs to be some blood. Now, critically,
Are you presuming that there will be testimony or the state will offer evidence of blood spatter, or you're?
yes, sir. I mean, well, I will say this, the state has indicated they're pondering that based on the evidence we've
I love the
come forward
judge's
with and
chair.
the difficulty, and I
It's
just want to make sure
epic.
for the record it's clear that in the process of conducting these tests, SWED has destroyed the T-shirt for the purposes of examination. And the way we became aware of that, and let me say this, I want to make this clear.
No, it's not clear if you
In
keep
no way
saying I want to
am
say this.
Inferring any untoward, illegal, unethical, dishonest conduct on the part of the Attorney General. I don't want that in any way to be inferred. I think he got
don't
those
infer it.
blood tests, the results of the blood tests the same time we got them, and we probably wouldn't have gotten them had he not asked to get all the reports through the attorney for SWED rather than going through the normal route.
Here's why the judge is so annoyed. Because the attorneys were standing up to talk about the motions that they were hearing. The judge never said we're calling this motion. The judge said, okay, we're going to go ahead in the order that they were filed in. And he just starts launching into his argument. They didn't really formally start the motion hearing. And this defense attorney is just like out of the gates and running, which is what he's done every hearing I've watched.
Since the shirt has been destroyed.
Shirt, not chart.
We went out and looked at it. We all, Mr. Zelenka, Mr.
They're talking
Waters,
about the blood
Mr.
spatter.
all went out and looked at it. And they could see
Or
it
lack
can't
of.
be tested again. We wanted, and what keyed that was us wanting microscopic, and I'm not talking electron microscope, I'm just you could use a magnifying glass basically to get the kind of photographs we wanted, that kind of detail. They couldn't do it. They can't do it, never will be able to do it. So as we looked at this further, Your Honor, we've done something in this case that most defense attorneys aren't able to or don't do. It's something we do routinely in a civil case. And that is to take
Not
the
a civil
discovery
case.
and put it in a database.
Not
which
a
is
civil
certain.
case.
And in my office, Holly Miller, this young lady right here, actually is a genius that knows, I mean, I couldn't find.
I don't give a fuck about your discovery
just
database. I'm
say
sure
that
it's
this
lovely.
clears the
And
record.
maybe she should come
I
and
in
do
no
mine because
way
mine's a mess.
take
But
any credit for for using a database to find anything. That's way beyond
This
my
is
capabilities.
Yeah, the state's
But
got
she
the money
found
for a discovery
in
database. Sure.
Something was labeled a memorandum of interview with Kenny Hughes. The draft report of Mr. Bevel, their expert, on blood spatter, in which he said there's no evidence of high velocity blood spatter. Not qualified. Now there's a PowerPoint that went with that apparently.
No evidence of high velocity blood spatter is interesting because it's going to indicate how close somebody might have been to the person who was shot and killed. This is a homicide case. We're going to be talking a lot about blood spatter. This is the defense attorney arguing that when they were digging through all the discovery, they're finding, it seems like what they're arguing is conflicting reports regarding blood spatter evidence. And that is if someone is standing there and shoots someone, the high velocity of the blood coming back out, depending on the types of weapons used and what have you. Am I a blood spatter expert? No. Have I tried cases involving blood spatter? Yes. Was it the only evidence? No. You better have else. You better have a lot. So they're arguing that the shirt Murdaugh was wearing has been destroyed through testing and they can't test it. And they don't have enough evidence. And there was a PowerPoint. Yeah, but when you're looking at a case where there might be reasonable doubt in an area where this defendant is not universally disliked, there are still people in this area that feel that the Murdaugh family has been through untold tragedy and that putting Alec Murdaugh on trial for the death of or the murder of his wife and son is cruel. So if you get a jury that feels that way, this could be a much more difficult case than the internet thinks it's going to be.
We haven't gotten, we've asked for. But he was unequivocal, no blood spatter. And blood spatter, high velocity blood spatter is created when you're near somebody and you shoot them and there's this sort of spray, a very, very small spray. So once we had that, we began asking questions and looking at.
Small spray is interesting though, because Murdaugh says he gets there after the murders. So if you're getting there after, if you're finding people that have been shot, there wouldn't be any blood spatter. You might have blood on you from if you show up and someone you know is injured, you are generally going to run and touch them. So if you are running up, you're not going to have spatter. You're going to have other type of blood on you. Spatter is coming, generally high velocity spatter is coming from and in sequence with a gunshot. So him saying he wasn't even there is going to be interesting if there is blood spatter because it contradicts his story or contradicts the 911 call.
The reports back from SWED, he was
not
supported
Sweat.
by that, by the DNA, which showed no Paul DNA in that area that we're talking about. And then we began going back to the report we got from the Attorney General a few months ago of the final report by Mr. Bevel, who is, by the way, not a forensic chemist. He's not anyway got any scientific degrees. He's a former police officer.
He doesn't need to be a chemist.
And he looks at patterns and determines what they are. And when we looked at that, he said, oh yeah, this is blood spatter. So we then began looking at the SWED reports. What happened after they found out no blood spatter? Well, the chief officer in charge
He said
of
there
this,
was blood
case,
spatter. What?
Upon receiving that report, had a Zoom call with Mr. Bevel. And Mr. Bevel said, would you mail me the shirt? And so I can look at it and confirm it can't be tested further. They said, no, we'll bring it to you. He said, no, all the time in federal court, they just mail it, they do a secure mailing. And they had actually offered to mail things to him, mail the shirt to him earlier. That was their offer, not his request. But they felt it was necessary for 2 SLED officers to fly out there. And what Mr. Bevel does, according to what we pieced together, is and by the way, all they have is a picture of the shirt. That's all he has.
If he argues like this in court, it's going to be a problem because a jury is going to be lost because we don't know what his point is. The judge has read 11 pages of whatever. So we don't know. But he's arguing that they can't test a shirt because it's been destroyed.
Picture of the samples in the shirt. And again, this is outside my wheelhouse, photoshopped the shirt.
What?
His statement photoshopped it to try to accentuate the little points. And in doing that, he now has an opinion it was blood spatter.
There's a difference between enhancing something and photoshopping something. I have questions.
Now, Your Honor, we're gravely concerned about what happened between the SLED agents and their so-called expert on that trip, and we have no emails, we have no communications between them, we don't know what they discussed, and by the way, there were, based on what we read, we believe there are other versions of this report we have not received. So there are other versions,
Okay.
emails, communications.
You have to they'll give them all
Did
of
they
that.
record the Zoom call? I mean, we do that routinely. So we have a record of what.
You recording the Zoom call and them recording is different. So I have questions. I think they might have used Photoshop to enhance it, but not add things to it. And I wouldn't be surprised if it was enhanced, but those things need to be known because again, when you enhance things, we get a pinch and zoom pixelation issue. Are pixels added? This has to be controlled for. You can't just enhance it with a photo program if you don't know how the photo program interprets data, which is the problem.
This person said or that person said. In addition to that, I think it's telling that in
Okay, our
this
point of focus isn't
process
so good right now.
revising this report 180 degrees, that Mr. Bevel relied on this Photoshop process. So one of the things we have made, the motion we filed, is a motion to compel the state to produce evidence regarding alteration of photographs of evidence it destroyed. In other words,
That's fair.
they took these photographs. We can't photograph it. It's destroyed. They somehow, in the process of doing the blood test, and again, we've got a
That can happen.
hematologist that expert said, this is something that chemist labs, crime labs do every day. The fact they destroyed it is so unusual that it boggles their minds. This is something they do. They can't destroy it testing it for blood because we have a right to test it.
They do have a right to test
The
it.
shirt still exists,
They shouldn't destroy it.
or does it?
The shirt exists, but it is dark purple or black, and there's no way you can see detail of the threads. So it is for forensic purposes, and I think the state is not going to argue you can test it. Mr. Bevel said you can't test it after he saw it, and the experts say you can't test it because it's been ruined for forensic purposes.
Which is a problem.
Whatever chemical treatments they put on it, they did wrong. In the sense that it made it unusable after.
If that's true, that's a problem.
Now, Your Honor, so we've made a motion to get, our first motion would be to.
So yes, it sounds like the shirt still exists. The shirt still exists, but the way they tested it made it untestable again, which is a problem. The defense has a right to test things. So if you use up the whole sample, you generally have to say why you're using up the whole sample. You have to document that you're using the whole sample, but this could be a problem. So the shirt being destroyed, in what he means by destroyed, and that's what he clarified to the court. This is where he doesn't mean like it's ash and you can't see it. The shirt exists, but you can't test it again for blood spatter. So yeah, the judge looks annoyed already. So it sounds like they are annoyed that the shirt is not testable.
Compel the state to produce evidence regarding alteration of photographs of evidence it destroyed.
Yeah, they have to.
And there's some very specific things on this Photoshop that we want the native Photoshop document that they created and used and then manipulated.
And that's
We
not
have very
unreasonable.
specific things we'd like. They exist, and we'd like the state to prove them so that we can see. I mean, prior to this Photoshopping, his opinion was no blood spatter. Then he Photoshops it, and now it is blood spatter, even though one of the points he finds on the shirt, he says now as part of the blood spatter, is negative, not negative, they exclude Paul Murdaugh as a contributor. So this becomes extremely important.
Whoa. He's trying to rely on it both ways. Like, it's just this teeny little dot of blood, which is also an interesting question. This is a white shirt that Paul Murdaugh was wearing. It was something over the shirt covering it is a big question here. So they are arguing, look, this enhanced evidence, it's destroyed, blah, blah, blah. But it says it's not Paul Murdaugh's DNA. So the blood says it's not Paul Murdaugh's DNA, Paul being the son who was murdered. So it's interesting that they're arguing it both ways. Like, it was destroyed for testing, but not this one test that shows that it wasn't the deceased. That one we're relying on. So it was testable enough for them to argue it. So they're arguing both sides, which is interesting.
Important for us to do was to have an evidentiary hearing where the SWED folks that conducted the tests, the agents that went and met with Mr. Bevel, produce all their emails, produce all the communications, produce the Zoom if they have it, and any notes they have of those meetings.
They're not going to produce the Zoom.
If Mr. Bevel has notes of those meetings or emails or other communications, we'd like those too. I mean, Your Honor, this was leaked to the press a year ago.
What was?
Alec Murdaugh had Paul Murdaugh blood spatter, was the shooter because he had blood spatter. That, first of all, SWED will testify there's no blood.
Obviously, if they tested something that said that it wasn't Paul Murdaugh's DNA, there was some blood. It's not that there's no blood, because you just said that there was and that it wasn't Paul Murdaugh's. So stop arguing inconsistent points. Also, what do you mean by leaked to the press? Do you mean that the press was speculating? What do you mean by leaked to the press? Do you think the police went to the press? The police were, I think, embarrassed because it took them so long to arrest him. It was over a year after the murders happened before they arrest Paul Murdaugh. The police aren't the ones telling the press, oh yeah, it's totally Paul Murdaugh. His blood's there was blood spatter on him, because the public was like, why hasn't anyone been arrested? So who's leaking this to the press? Who? Not the prosecutors. They don't want the public looking at them and being like, why haven't you arrested anybody yet? So who's leaking this to the press? This is bananas of an argument. Not the buffering. Not the buffering.
So I don't know how you have blood spatter. Number two, the DNA spot would exclude Paul. Exclude him. And number three, we believe the forensics
there's no blood, but the blood that there is excludes Paul.
is going to show that whoever shot Paul Murdaugh and basically blew his head off would be covered in blood, not just spattered.
That's new information.
Now, we reached out to Mr. Bevel, wrote him a letter, said, here's the motions we filed. We'd like to talk to you. He got back to us yesterday. Your Honor, if I could hand you a copy.
Yes, sir.
Just the email.
Sorry, y'all, this is a first look at this, but it is a murder case.
From Mr. Bevel.
It shouldn't be tremendously graphic. He's just launched into
Which he
arguing. I think he's still in the
indicated
middle
he'd
of an
be-
objection, and the prosecution's like, what the fuck is happening? But they're just letting him go.
Different email. I'm sorry, Your Honor, I handed you the wrong email. Let me see what I handed you. This one's.
So they are trying to figure
No,
out
no, this is
what
not
they're
right.
handing to the court, and if the prosecutor has what they're handing to the
I
court.
think I handed you I had two emails. Handed you the wrong one, Your Honor.
Thank you, Michaela.
Your Honor,
Tina
what he
said
says is.
this community does more
first,
than
my
pledge.
apologies in not getting back to you sooner. We've been dealing with 2 deaths in our family a week apart, which put many things on hold.
That sucks.
Our company policy is always to honor a request to speak to an attorney about an active case. We always invite the opposing attorney to listen or be present for the interview, and have done so.
It's not just me.
In this case, I've not heard back from possible open dates, but I'll be available when dates are identified. I assume you will allow us to talk to him with you present?
Absolutely, that's what we've told them.
Okay. Secondly, Your Honor, we need an evidentiary hearing after we have a chance to talk to Mr. Bevel. We'd like to subpoena all these SLED folks to come testify, but we'd like to get the documents from Mr. Bevel.
The purpose of the hearing would be what?
Pardon?
What's the purpose of the hearing?
The purpose of the hearing, Your Honor, is to develop.
The judge is like, why do I have to sit here through this shit? Tell me why. I don't want to do it. What is the purpose of having a hearing about it? Can't y'all just have the interview?
A basis to determine whether or not we want to make a motion to exclude the shirt. Right now, we think there's
You don't need a
lots of
hearing
stuff
for that.
here, but we need to understand, for instance, under
Have the interview, then make have the interview and then make the
Cheeseborough.
motion.
Under the Cheeseborough case, we not only have to
this
show
judge,
they
this
destroyed the
chair is
evidence
gold.
or altered the evidence, but we have to show it was done in bad faith. And that's why we need to ask what happened. Was it reckless? Was it beyond what's normal? What did they do wrong? And secondly, we can't develop that without talking to these folks at the minimum. And I'd like them under oath when we talk to them. Also on the
prosecutor
Photoshop
just
piece,
agreed that
we need to understand how he did it, so that we then can determine whether or not his, now that would be for a counsel hearing at a later date. I don't want a counsel hearing. I just need an evidentiary hearing to determine whether or not we have to hire additional experts.
this case is in like a month, bro.
You want this hearing for me to order them to produce information for us to then have another hearing so that you can then determine whether you're going to file a motion to exclude the evidence at trial. Evidence that I don't know will be, to say the Tim's awful.
Well, by then, hopefully we'll get I mean, I know that the Attorney General's trying to work through this, and in his defense, I don't think he had a lot of this. I know he didn't have a lot of this before we.
He doesn't need you to defend him if you're not attacking him. This is not a civil case. He wants this to be protracted like a civil case. And the judge is like, really? You want a hearing about a hearing to have a hearing? Like what we're not doing. So, Maddie, these are not Brady violations because they are in the process. They have turned stuff over and he's asking for more detail, more interviews. He's aware of who the witnesses are. He's aware of what the evidence is. So this isn't here's this report that no one knew existed. This is them going through more detail of this is what exists. He wants this to run like a civil case. He wants this to run where he knows everything beforehand. That's not how criminal cases run. You're not going to get to depose everyone. That's not what's going to happen. So let us continue. This courtroom is very well lit and looks so pleasant. It does. And apparently Alec Murdaugh's like South Carolina, granddaddy or great-great-granddaddy is hanging on the wall somewhere. So that's going to come up later in this hearing if we ever get to it, because I keep pausing.
Yeah, now, why that is.
The court reporter is over it.
I think he would give you a more benign explanation. But when I see a draft report saying it's not blood spatter,
I love
hidden
that
in the
chair.
wrong file.
I need a better
And by
chair.
the way, they said, at some point, they said, we always had it. Again, we're getting a terabyte of data and looking for a needle in that terabyte haystack.
Oh, boo-hoo.
So I understand the motion. I'm going to give Mr.
Oh, look.
Waters an opportunity to
Louise.
respond to the motion.
So
Thank you for that
Yes,
tremendous super chat.
Yes, sir. Am I done?
Yes, sir. Mr. Waters.
Blessedly, am I done? The court is like, yeah, the fuck you are. Thank you, Louise. I appreciate that super chat. That is tremendously, tremendously kind and supportive. And it is y'all that make it possible to do all the things we do here. So thank you. I know the media gets a little salty. It's like people are like paying directly to these YouTubers to do the coverage. It's like, yes, it's kind of like putting stuff behind a paywall. I don't want to put stuff behind a paywall. So those who can do, and we just, it all works. So thank you so much. Is this civil attorney trying to practice criminal law? I think he does both, but I think he wants this case to run more like a civil case because there's a terabyte of data and he wants it to be ordered under the rules of civil discovery versus others. So yeah. Is this being filmed in cinematic mode on an iPhone? It feels like it. but at least the audio's good. All right.
Orders.
See what the prosecutor has to say.
Please, court. Your Honor, I, of course, had a conversation with Mr. Harpootlian.
I like
know
the
last
cinematic
Friday, y'all were in with the jury in the trial that you were doing, and we had a chance to speak about this.
They should just search
about
it.
the motion that he's filed. And I would say that at this point, a ruling from Your Honor, I think, is premature, because what I expressed to Mr. Harpootlian then and what I've expressed here today is that we're in the process of assessing the viability of some of the information that's been gathered and how that affects this report, and ultimately whether or not it is anything the state intends to offer. I've expressed to them as well that I will fully advise them of that particular process and what we uncover and my decision and the reasons for that decision. And then at that time, assuming that there's
I'm obsessed with this,
an
Judge.
issue to be had, that they could then litigate it at the time. What we've found out, unfortunately, is that that November report with the hemotrace was not provided to our office through the normal discovery. And
I appreciate that did you catch that? The prosecutor is calling it the hemotrace, which is the technical name for the blood spatter, instead of being sensationalistic, which he gets accused of a lot. Harpootlian is the one who gets sensational in court, but he accuses the prosecutor of grandstanding. The prosecutor's talking to the judge like the judge. So, yeah, the hemotrace, use of language for hemotrace is interesting, but y'all learned something new today. It's like when we heard about fecal phobia and then never heard about it again. So we will continue.
in fact, I did not receive that report until last Wednesday, November the 30th, when I literally was at SLED attempting to figure out our response to the motions after it had been filed, of course, the day before Thanksgiving. I set up the meeting, we went out there, and literally was out there going, what report are we talking about? And that's when the report actually first really came to my attention.
What report are you referring to?
There is a November report, November 2021 report, Your Honor.
Lawyers, especially criminal lawyers. It's interesting that we've gotten this close to trial, but remember, Alec Murdaugh is pushing this case to trial within the time period very, very quickly. It's an interesting strategy. It could backfire on him. It could work well for him because it doesn't give the prosecution a lot of time. So they are pushing this within speedy trial timelines, which is unusual in a homicide case, especially in a double homicide case. But what he said is, I didn't become aware of this report until I went out and met with the investigators. This is critical for prosecutors to do. There have been more times than I can count where I have had to sit down, and then it became my standard of practice, where I had to sit down with like a murder book with my investigators and go page by page. What's in your book? What's in my book? Let's show me the evidence at the department, and had to leave your office and go and do the legwork, because occasionally the lead detective might not be liaising with the forensic people who work at a completely different location, and forensics had another report that they didn't send. You as a prosecutor are responsible for unearthing all of that, and a lot of times you just have to go. You have to go and do it, and that's what he did. I went and sat down with them, and that's when I found these reports. It has to be done. They could have done it faster, but here we are. So yes, I am not going to be able to call them solicitors. It always makes me think of England. But yes, I know the reason I know they're solicitors is because Alec Murdaugh's family lineage, they were the lead, essentially, district attorneys of their county for like 100+ years. They were the head solicitor, but same. Solicitor, prosecutor. Look, I didn't realize that if you were in Canada or the UK, you got to be the crown prosecutor. I was like, what? Instead of saying for the people, you say for the crown. How fucking cool is that?
In which SLED had tested various cuttings from the shirt with hemotrace, which tests for human blood, and that it had not identified human blood on those particular samples.
That's a big deal.
So just to back up a little bit, obviously, the Attorney General's office was not involved in this case for the first 3 months. I did not get involved until September of 2021. The case at the time was with the 14th Circuit. In July of 2021, SLED Forensics
this is before the arrest.
Looking at various things they could do to test the shirt, and they applied a substance which is very common and commonly used called LCV to the shirt, which reacts which can react with blood. And
To
that's what
bring
they
it
keep talking
to the
about it being
forefront.
destroyed. It's not destroyed. The shirt is still there. It's just that a consequence of that testing on the shirt is that it then becomes discolored. So it's kind of purple. That's actually what it does, is that you can see the alleged blood on there. During the course of that
Very
testing,
good
after
with
they
saying
did
alleged.
that, they then, I think subsequent to that, and bear with me, Your Honor.
Is he not even listening? The defense attorney's just over talking at the table while the prosecutor's talking. Okay, cool.
Yes, it just in September, they then reached out to Mr. Bevel, and again, this was SLED doing this, reached out to Mr. Bevel to get him to ultimately review the case, and then that process went forward. The Attorney General's office, we had no involvement in any of the interaction with Bevel. The only involvement that I did actually have during the process of dealing with Mr. Bevel was when they actually called me and said, hey, Mr. Bevel says that we can mail the shirt. And I said, no, you ain't mailing no shirt. This case is too important. I want it always in the custody, direct custody of a law enforcement officer. So that was what I said at that time, but it was more about just the importance of this case and ensuring that a major piece of evidence didn't get lost in the mail or something else happened that would
That would be a
affect
disaster.
chain of custody and the security of that evidence.
Is it anticipated that Mr. Bevel will be a witness in the case?
Well, and so
Yes.
ultimately, when this report has come to light, the first thing that
Just
I
yes
did,
or
of
no?
course, was talk to the SLED experts and talk to Mr. Bevel. And I said, how do we assess this? Is this, how does this affect the report? Is it going to undermine at least that aspect of the report? Is it going to, the conclusions are still there, but maybe not as strong? Or is it something that we need to not pursue? And obviously, I immediately started to ask SLED to begin
He is in
that
custody.
process of determining the effect of that
So he is
evidence.
in
And that
custody.
process is ongoing. We had a meeting.
I have no idea how he's paying for
yesterday,
attorneys.
where I sent some of my folks out there to do that, to assess the effect of this hemotrace, and there's a number of factors to consider. There's a number of factors to consider as to the dilution, as to the location, as to possible reaction of LCV to the hemotrace test, in order to determine whether or not there is any significant possibility of a false negative on those tests. And that's exactly
So the answer is yes, no, or you don't know yet.
the answer is that we do not know yet, and that's what I've told Mr. Harpootlian. I told him Friday and today.
I'm going to love
Mr.
this judge
Bevel,
so
the
much.
email that you just got, unfortunately, has been out of pocket, and he was going to do that same process in assessing whether or not the effect of this report on his ultimate conclusion. And he, unfortunately, because of deaths in the family, has been out of pocket. But as I've told the defense, the second
That's such
that
a
I get
prosecutor way to say that.
reasoned answers to the science of this,
Exactly what
I
you
will
would say.
assess whether or not what that means to the viability of this evidence. I will, of course, advise the defense, and in the event that we decide that it's still viable in some way or form or fashion, then at that time, I think it would be appropriate for them to litigate however they want to litigate the issue.
We don't know
And
if this
that's
evidence is
exactly
coming
what
in
we're
yet.
going to do, and-
What is your response to his motion to compel the communications and all of the other,
We have and are providing every,
Question.
I'm sorry, Your Honor, let me interrupt.
go ahead.
We have and we are providing every single thing related to Bevel to the defense. And in fact, again, that's how
'Cause you have
some
to.
of this stuff, has ultimately come to light. So I don't think there's any need for any motion to compel, because anything
not trying to
that
play
we
hide the
have that's
ball.
Bevel related, they're going to have. And anything about this process, they're going to have. And the reasons for any decision that I make, they're going to have. And then again, they can bring that to your court if they're
I think
unsatisfied.
the basis for the motion is that they do not currently have it and they want it.
And again, I believe that we've provided every single thing that we have, and there's nothing Bevel-related that we are withholding, that we intend to withhold. And again,
You
this is an
can't
open
withhold-
book process
the
with
law
defense.
is the law.
We
You
will
can't
understand
withhold
the reasons
anything.
for my decision, and they can respond accordingly at that time. But I think it's appropriate that we give time for the scientists to assess the
I mean,
science
sometimes.
and to ultimately come up to whatever conclusion that is. They'll advise me of that. I'll advise the defense of that, as well as my decision. It may be that this is an
I love this judge.
Your
He asked a
Honor,
question. The judge said, is this person going to be a witness at trial? And we got like a 5-minute explanation. The judge is like, yes, no, don't know yet. This judge is going to go up there with Judge A on Judges I Love. A lot of this kind of long-windedness, and I get the same way. I want to explain myself. My husband's like, you've explained yourself twice. And I'm like, just let me finish explaining myself. That some of that shouldn't happen in front of the trial or in front of the jury. A lot of this is for the court to try to explain back and forth, and they know the media is there. So these are theories of the case leading up to trial that's like literally next month. There's a lot of work to be done on this case before next month.
Two things. One, I believe they're obligated to give us whatever Mr. Bevel has.
Yes.
In addition, and I'm not sure that we've gotten everything from them. And let
They
me say
said they
this,
were
you know,
going to. Calm
we got some
down.
phone stuff. We got stuff last night, phone records that we asked for 3 months ago. We got a trial 5 weeks from now.
It's the government.
And, you know,
What
I
would
don't
you-
particularly want to be litigating this over the week before Christmas or the week after Christmas. We've
Boo-hoo. Don't set your trial for the end of January. You're going to be litigating this shit around Christmas.
got work to do. So we'd ask Your Honor to order the state to provide us everything Mr. Bevel has, all his notes, any communications he has. Your Honor, let me put this in context for you. Mr. Bevel goes around
We
the
don't need
country testifying
context.
about blood spatter.
Goddamn.
He testified in Indiana in a case named Cann, C-A-N-N. The jury acquitted the man. He said definitely had the blood spatter of his wife and dead children on him. They did put, there's a national system to look for DNA, which the state then did. They have not done in this case.
This is impeachment if the
And
witness is
They
called.
identified a guy named Boney, arrested him, and convicted him.
Boney?
But for
The Boney can?
some of the experts we've been talking to questioning Mr. Bevel's art, and or it's not a science, that young man would have been convicted and doing life, going to the electric chair. So this is critical because this blood spatter, this guy's not a scientist. He looks at something and gives it
This
sort of a
is an evidentiary motion. You're telling the prosecutor what your impeachment of this witness is, should they choose to call this witness. None of this is relevant at the moment. Why are you banging on and on that this witness is not a good witness? This is a compromised witness. Like, what in the world are you doing arguing this right now? This is not relevant to the motion you're there for. This is a motion to exclude a witness. This witness hasn't even been called yet. This is not the time for this.
Rorschach test. He had originally looked at it and said, nah, no blood spatter. Then he photoshops it and says, yeah, blood spatter. We need to understand why he changed his mind. And we'd like to, ultimately, we need this evidence to get in a position. We're going to assume that he's going to go forward with it. But we can't wait until he makes his decision to get this information.
Welcome to criminal
begin
practice.
Working to get ready for, maybe we won't have a hearing, but we need to be ready if we do. And we're 5 weeks out now.
Yeah, we are.
Anything else on this motion? Yes, sir.
Very quickly, Your Honor, a couple of things. Number one, I believe, I mean, I don't have custody or control of Mr. Bevel's notes. He's not a state actor. I do have, and we have provided every communication that I'm aware of between SLED and Mr. Bevel, as well as the drafts and everything else. So I'm not aware of anything outstanding, but Your Honor, we're not going to withhold anything in that regard.
Yeah,
Secondly,
right.
He mentioned some stuff that was provided
This is an
yesterday.
expert
was some
that
of the
doesn't
stuff
work for
came
the
from
state.
14th Circuit,
Interesting.
but it is my understanding is duplicate, so we're providing out of an abundance of caution in that regard. In any event,
No.
Your Honor, again, there's nothing, I don't believe that is Bevel related that we possess that we have not already provided to the defense. And if I uncover anything else, first people that will get it will be him.
Fine.
Your Honor, could I just make two things? There's a PowerPoint referred to in the original Bevel report in which he says no blood spatter. We don't have that. We have very specific information we want on the whatchamacallit that he did of the blood spatter.
Your Honor, can you
Photoshop.
order them to turn over the
We need
whatchamacallit?
that,
Please.
for our experts to be able to analyze whether or not, this is voodoo
Yes,
science
Cheryl.
or whether this is the real thing. And again, this is a guy who goes
An
around the
argument for
country
the
doing
jury.
this, and has been wrong in the past. So we need that.
That's
information.
impeachment.
On the issue,
Yes, yes.
motions and what's at stake, and I reviewed your motion. I grant the motion to compel, if you would prepare a proposed order and share it with Mr. Waters, and I review it and issue a written order
Thank you, Your Honor.
based on that.
Thank you, Judge.
Turn over what you have. Oh, yeah, he said voodoo science. He said the whatchamacallit of the voodoo science. That's what he
The
said.
next motion,
Yes, the whatchamacallit
Yes, sir.
does still
The next
exist.
motion, of course, deals with the bill of particulars as well as the state's alternative motion in limine for admission of evidence as to the various exceptions on the 404B, such as motive, intent, common
Motive.
scheme or plan, identity. And
Oh.
we had a conversation again last Friday about that, and ultimately discussed the fact that they would file a bill of particulars, to which we have responded.
No jury. Those
We
are just law
ultimately,
enforcement
in our
officers sitting in the jury box.
Object procedurally to the bill of particulars as not a viable procedural mechanism under South Carolina law, but take the position alternatively,
federal.
though, that this is an issue that we need to assess with the court as we move forward because of how important it is to the case. And of course, filed a detailed response that Your Honor would have yesterday. And the reason for that is, Your Honor, is that in this particular case, where you have a man who was accused and indicted for the murder of his own wife and son, that motive might be the most important fact that any jury would
Yes,
want to know.
tell us.
It's not an element of the offense, but it is the most important fact that any jury is going to want to know in this case. And for a jury to understand that, for them to really understand what the motive is in this particular case.
I'm going to pause real
they're
quick.
going to
He's asking for 404 evidence, meaning other evidence of other acts to explain why this happened. So a lot of things can and cannot come in a criminal case, including like ancillary shit that is going on. This case is just about these murders. So the prosecution is saying we need all this other stuff to come in to prove the motive of why these murders happen. We need to be able to tell the story, and we haven't really heard that. I'm very interested to see what they think the motive is for why they're accusing Alec Murdaugh of murdering his wife and kid.
have to understand that there was a huge difference between who Alec Murdaugh professed to be to the outside world and how important that was to him
Images
as
everything.
a central figure in this prominent family, and who he really was, that only he knew, that no one else knew. Over and over again, I've interviewed witnesses or put witnesses on the stand and who thought that they knew this man, and they over and over again said, I didn't know him. I didn't know who this man was. And so for a jury to understand that, they're going to have to understand not only that distinction between who he professed to be and who he was and how important that was to him, but also how that allowed him to avoid accountability for defrauding victims of almost $9 million since 2011 that we've been able to detect.
Abdicate his
I
accountability.
think when this case started, a lot of people assumed that this was a murder case, and then a few months later, there was some white collar thrown in there. But the reality is we have done this extensive investigation, state grand jury investigation. We've realized that this is a white collar case that culminated with two murders.
The murder is the cover up. That's what I was wondering, if the murder was the
And
cover
so
up.
if you look at the development
I
of
was
this
wondering if the
particular
murder was the
case
cover
and
up for
evidence
everything
in
else
this
falling
particular
apart.
case, what we see is that the defendant in the late 2000s, and that's a long time to go back, and I recognize that, Your Honor, but I think the important point to realize is that this is an unbroken chain of constant lies and misappropriations and thefts that has been going on for so long, a hamster wheel on which this man has been on constantly, having to borrow, to earn, to steal millions of dollars just to keep kicking the can down the road and staying above water, an exhausting hamster wheel. A slow burn that was heating up until June the 7th, 2021. And it all started with some land deals in 2008, 2007, 2008. The recession hit, and he really ended up upside down on those land deals. And it materially changed his financial picture. The reason why we know that, Your
As it did
Honor,
for a lot
is
of
that
people.
in early part of this past decade, in 2011, he had some big cases. He had the Pinckney case. He had the Thomas case. He had the Badger case. And these cases, the people around him thought, they knew he'd had some issues and had some problems, but they thought that those recoveries and those really high fees that he had obtained, 6 figures or more, had fixed the financial problems that Alec Murdaugh had.
I really want to hear the motive stuff. He is being charged in this case with the murder of his wife and son. The son that was murdered, who is deceased, is the one who was at the helm of the boat crash that killed Mallory Beach. There's a whole other line, and again, I break that down in an episode of the Emily Show, and the Murdaugh Murders podcast goes into depth. But I have an episode of the Emily Show where I walk through the timeline of this case from the Samuel Smith unusual circumstance death that is connected to this family and all the way through. So there are quite a lot of questions here. This part of this case is he's been charged in this part of this case with the homicide of his wife and son and a few other charges. So let us continue.
But they didn't. They weren't enough. And not only did he have huge fees from those particular cases, but he also stole money from the clients as well.
That's going to come up here, Tina.
Your Honor, if I look at the unbroken chain that I'm talking about here of these thefts that went on.
There are questions. He has not been charged with any other murders.
And every
Stephen
single
Smith, thank you
year
so much.
From 2011 to 2021, he stole money from clients. It is an unbroken chain.
That's wild.
Because even though he was making 6 and sometimes 7 figures of legitimate income in his law practice, it was not enough to sustain the lifestyle that he had and the debts that he had.
Lavish
Even
lifestyle.
though he
Lavish lifestyle is going on the bingo board. There's the lavish lifestyle. Rob, this opening statement should be simple. The prosecutors are arguing here in front of the judge. They need to make this case simple. And it's as simple as, the prosecutor's theory of the case is what this evidence is going to show is that Alec Murdaugh was on a hamster wheel to fund the image that everyone thought that he was, to live a lavish lifestyle, to be who you saw, who the public saw as a pillar of this community. But what was going on behind the scenes was darker. It is an unbroken chain of theft from clients and desperately trying to keep up with the image he was portraying. And when that house of cards began to crumble, his wife and son knew too much, or he needed to buy himself time, whichever theory they're going with, before the loans all came due. And he perpetrated this murder to cover up the other crimes. It needs to be a simple and concise opening. And they should really keep it to the story, the thread of the story. We'll see what they do. But yes, it should be. It should be. Is this trial going to be podcast? Yes, it is. I'm going to be covering it day by day trial coverage.
millions of dollars from Calumet State Bank, from his buddy Russell Lafitte,
Who was just convicted in
borrowing
federal court.
close to $1 million from his law partner, borrowing hundreds of thousands of dollars from his father, borrowing hundreds of thousands of dollars from Russell Lafitte's father, having Russell Lafitte loan him close to $1 million from the Plyler money, for which he had Russell appointed conservator.
Money.
It still wasn't enough.
Money.
It wasn't enough to keep Alec Murdaugh's head above water.
Never enough.
And it couldn't stop. It couldn't stop. I've detailed in the filing, and Your Honor is generally familiar with the state grand jury evidence of the 4 manners in which he was stealing money, including from his own family and his law firm. And he had been doing that for a long time. But one thing happened that caused the slow burn to finally heat up.
What? The Mallory
And
Beach
that was the
boat
boat
crash?
case.
The Mallory Beach
February of
boat case.
2019. Your Honor, I've done a lot of white-collar crime, and
Me too.
like every Ponzi scheme, theoretically a Ponzi can last forever as long as there's new money. But the second that money stops or slows down, it's inevitably going to crash and burn.
Like the Girardi law firm.
That is what the boat case meant here.
So the
That is
boat
what
case
case
tipped
is
the
about
house of
here.
cards.
And so what we see after the boat case is we see a huge uptick in the amount of money that he is stealing. And the biggest one of that is the Satterfields. And that one's different because he's actually the defendant in that particular case. He's not the plaintiff's attorney there. And what he does is conspire with his buddy, Corey.
The boat case, his son was driving a boat drunk at night and they hit a bridge pylon and killed one of his friends, Mallory Beach, injured the others in the boat. So when they talk about the boat case, what he's talking about is that boating under the influence death of Mallory Beach that his younger son was criminally charged for. There's a lot of fucking shenanigans that went on with that case, with alleged police cover-ups. There's civil suits. Again, I cover it in that breakdown, but he's saying that the house of cards toppled with the Beach case because, well, we're gonna keep hearing it. So with that, we're now getting into the Satterfield case. The Satterfield case is the case with their house manager who nannied their kids who died on their property. So that's what they're starting to talk about in that case. Again, fucking shenanigans, but Alec Murdaugh went to the two sons of Gloria Satterfield and said, hey, use this attorney, sue me and my insurance. If you sue me and my insurance with this attorney who I'm hooking you up with, then we'll be able to get you compensated and we'll take care of it since she passed on our property. Then he essentially is accused of stealing the money. So with that, he's accused of stealing the money. So that case is also got a whole bunch of civil cases, but Alec Murdaugh admitted to stealing the money in that case. It also, that case coming to light unwound his law firm, PMPED, and it broke into other law firms. So that's a quick breakdown on the Satterfield case that they're talking about. So, Tina G said Paul was not driving the boat. This is an assumption Mandy makes that is not a fact. It looks okay. I've looked at a lot of this. He was not convicted in a court of law. It looked to me like he was the one driving the boat from all of the things I have looked at in this case. But this is what the prosecution is going with as well, that the death of Mallory Beach in their boat that they believed is helmed by Paul. And I believe what others in the boat have said, but it's fair that it was never litigated in court. We are still seeing the civil litigations happen. So with Paul dead, that ended the boat case. It did not end the boat case. It ended the criminal part of the boat case. The civil parts of the boat case are still going on. And again, there's investigations into whether there was malfeasance with the investigation into the boat case. So we're not going to argue the boat case today because we're arguing this. The prosecutor's theory of this case is that the boat case unraveled this house of cards, and then the Mallory Beach case went forward. So there's a lot going on with the boat case, and a lot of it is Alec Murdaugh is accused of messing with the investigation in that boat case. That's an accusation. So I don't think so. There's a lot of civil lawsuits going on with the boat case. So it has not been proven in a court of law. But again, Murdaugh was involved in allegedly trying to place the blame on others in that case. So let's keep going.
Fleming to get a recovery against his own insurance company for her fall at his house, and then has Corey Fleming write the check out to the fake Forge account
and steal the money.
$2.9 million. And unlike prior to the boat case, where he's able to pull off a sleight of hand of stealing money from clients in plain sight with stuff on the disbursement forms and the sheets that they're signing, because at the same time, he's handing them a huge check of life-changing money, and they're shaking his hand as they walk out the door. Here, with the Satterfields, after the boat case, he takes it all. He takes every dime.
From her sons.
What does that mean? Well, one thing it means is that he doesn't have that umbrella policy anymore. And so the boat case becomes very significant because the plaintiffs in the boat case made it very clear that this was not just about recovering from an insurance company or recovering from the deep pockets of the convenience store or the bar. The plaintiffs
That
wanted
served
a
the minors
specific
alcohol.
personal recovery from Alec Murdaugh because they believed, like everyone,
Those are still going.
that he had a lot of money. And it was the principle of the thing that they wanted him to pay. Personal, if there was going to be any settlement. And as that time went on, the boat case plaintiffs made it very clear to Alec Murdaugh's civil attorneys that we want a personal recovery from Alec Murdaugh. And they finally,
want
his
him to
attorneys
pay.
finally tell them, and they say, he doesn't have any money. And they're incredulous. They don't believe that because, like everyone, they believe he's very wealthy. And they file a motion to compel,
Like
to
the Girardi
disclose his
case.
accounts, to disclose his finances.
Shocked.
Disclose all of that.
Shocked
That hearing
that
is
the money
initially
was
set
gone.
for May of 2021, but it gets continued because
Of the
Mr.
hump.
Murdaugh's attorney, John Tiller, who's of course deceased now, was having medical treatments.
These financial disclosure hearings were set less than a month before the murders. So the timeline in this is important. If their theory of the case is that the way that the Mallory Beach case was unwinding was going to expose this fraud. So that seems to be the direction they're going in. And those hearings were supposed to happen less than a month before the murders. And the attorney was having health issues, the attorney who can't answer because the attorney is now deceased.
What else is going on at this time is we're in now the spring of 2021.
is stranger than
Well,
fiction.
state grand jury subpoenas are being issued as well about the boat case
Yep.
out in Hampton and Colleton counties. And what else is going on at this particular time?
Yep. Tell us.
Alec
So
Murdaugh
this is their timeline
has
of their
an opportunity
motive.
for a big recovery in a case he has with Chris Wilson. And he actually argues
3 or 4 weeks.
and agrees to get the defendants, who were a big automotive
Maybe more.
company, and he gets them to agree to what seemed like a really good move at the time. He gets them to say he's going to waive punitive damages if they waive the right to appeal.
What?
So that it's going to be bench tried, and so whatever decision is made, bench tried on just damages, then that money is going to be instantly available.
One more.
That
Just
might
like
seem like a good
Girardi.
strategic move, but
One
the
more
reality
case.
is that
One
Alec
more
Murdaugh
case.
needs
One more
that money
case.
right now.
One more case.
Because the way the law firm worked is that you don't get your bonus until the end of the year. And other than that, you just get a $125,000 salary
Just.
spread out over the course of the year. For a person that the second he gets an infusion of cash, high six figures, it's gone within months. So that case happens. The judge issues his ruling, and ultimately it's a pretty good recovery, and there's $792,000 in fees for Mr. Murdaugh. But what he does
Almost
is he
$1 million in
convinces
fees.
his co-counsel in that case to write those fees directly to him instead of writing it to the firm. And why is that? So that he can get that money right away and bypass the firm where it's supposed to go.
Because the money's
And so
all
he
supposed to go
does
into the
that.
collective firm.
$750,000, and it's gone within a very, very short period of time. In May of 2021, though, his staff, Mr. Murdaugh's staff, becomes suspicious because they get the expense check and they don't have the fee check. And
That's
they call
interesting.
up the other attorney's office and they say, "Where's the fee?"
'Cause the
Fees.
firm-
And initially the paralegal was like, "Well, we gave it to Alec."
That's interesting because the firm says that they were not aware of any of this till the Satterfield stuff went down. So the prosecution's arguing to the court, no, the firm was alerted to this at this time. So Emily, is there any way you can do an outline of this case? I did on the Emily Show podcast. It is on my YouTube channel. There is an outline that goes through the entire timeline before this arrest for the murder. I'm going to be doing an updated one next month, but there is one up on the channel. So it's on the playlist and it's on the podcast. So yes, there is one. So if you guys haven't checked out the Emily Show podcast, do that and do the YouTube things, the likey, subscribe, YouTube things. Let's keep going. We're going to do another part of the giveaway in just a few minutes. Oh my goodness.
And then they're trying to figure it out and they can't get a satisfactory answer. And they go up and talk to financial staff and they're trying to get a straight answer and they can't get a straight answer. And one of the attorneys calls that other attorney and they can't seem to figure it out. Where are these fees?
I have one.
Where is $792,000 in fees?
Yep.
He's already gotten it. He's already spent it.
Yes, there is.
He doesn't have the means to pay it back. So what happens?
We're going to do the
on
third
June
giveaway
10th?
in a minute.
All of this is finally coming to a head. That morning, a PMPED staffer comes in the office at the direction of the partners and says, Alec, I need an answer today. Where is that money? I need an answer today.
On the giveaways, you can enter each round, but when you enter, your entry will only be counted once. So once you enter with the keyword, it's only entered once, but you can enter each round. So we're coming up on our third round. We're going to do some more of these on Thursday, and I'm going to be offering giveaways over on social. So no, you didn't miss it. Here's the playlist for YouTube. I'm also going to put a link, and we'll put it in the description of that particular episode for the Murdaugh case. And so we'll have the links to kind of my overview episode. But yes, it is on the podcast and it is here on YouTube. So we're going to do the giveaway in just a minute.
Alec is in his office working on the boat case because that hearing is scheduled for June 10th. And Judge Hall has made it very clear there's going to be no more continuances. And that's going to expose everything as well. And the only thing that stops the conversation about I need an answer right now is that Alec, unfortunately, gets a call that Mr. Randolph had gone into the hospital with a very poor prognosis. His father, who repeatedly had loaned him hundreds of thousands of dollars when he needed it. All of those are happening on this very day.
No, we're not doing the giveaway now,
Today,
you guys. Don't
reckoning.
enter it. We're
Yeah.
doing a new keyword in a minute.
The very day
Don't do it now.
that Maggie and Paul were murdered. And what happens in the wake of that? What happens is the exact opposite happens. Everybody immediately rallies to his aid. Immediately, that hearing is canceled. It's not even rescheduled anytime soon. The PMP.
That's huge. I'm going to back that up just a second. This is the motive. This is the motive. Everything stops. Everybody looking into it. Everyone looking into this stops. So.
That Mr. Randolph had gone into the hospital with a very poor prognosis. His father, who repeatedly had loaned him hundreds of thousands of dollars when he needed it.
His
All
dad's
of those
sick.
are happening on this very day. It's a day of reckoning for him. The very day that Maggie and Paul were murdered. And what happens in the wake of that? What happens is the exact opposite happens. Everybody immediately rallies to his aid. Immediately, that hearing is canceled. It's not even rescheduled anytime soon.
That's wild.
The PMPED people, it would be, the last thing they're worried about is where these fees are. They don't care about that anymore. They're all rallying to his aid. All of the things that were about to happen stop.
Yep. It
And
doesn't
what does he
crumble
do in
down.
the interim? The first thing he does, one of the first things he does, at least business-wise, is get more money from one of his law partners, get more money from Russell Lafitte from Palmetto State Bank in order to send enough money to Chris Wilson that Chris Wilson will then send it to PMPED and say, yeah, those fees were there the whole time. Everything's cool. He covers his tracks. And that would have
Interesting.
never happened if it wasn't for the deaths of Maggie and Paul.
Everything
It never
stopped.
happened. And the only thing that changed was that in September, a PMPED staffer happened to find a copy of the check that was written from the other lawyer, directly made out to
Which
Ellen.
toppled it.
And she knew right then that he had been lying about it. And she takes it to another staffer, and that triggers another staffer to think about some other forged checks that have been made out that didn't seem quite right. And they go look at those checks, and then they run it through the system, and all of a sudden, all the forged checks start popping up.
Here's why forged matters. They don't mean forged checks. They don't mean faked checks. Forge is it's something Tom Girardi could have used. Forged is a clearinghouse where you can have civil client wins go in and then held, and then those funds are then distributed to the plaintiffs. So if somebody won a $10 million judgment, they can put it in a forge account that is not the attorney's account. It is their account, and then it's distributed to them. It's alleged that Alec Murdaugh made an account named Forge so it would look like money was going to this kind of plaintiff's clearinghouse when it was really going to him. So this wasn't like a accidental. No, we don't have a third hashtag. The chat has just gotten wild. Let's do a third hashtag now. Let's do our third hashtag now. So we need one more giveaway. I will tell you what the hashtag is going to be. Let's do this right now. I need to choose the broadcast. We're going to do hashtag trial. Hold on. Now you can go. Hashtag trial. Hashtag trial. So chat is unruly. You might have done it, Rob, but hashtag trial, put your entries in. We're going to watch a little bit longer and let those entries roll in for this. And then we will get back to this and then to Q&A. We've got some time. We're here today. We're just rolling. We're rolling. Let's continue on. So that's why not forged. That's why forge matters. We have to talk about the Russell Laffitte federal prosecution. He's one of the bankers involved in all of this. Some of the bankers involved in this are being federally prosecuted. So only one entry per person. That's correct. One hashtag trial is all you need to enter. Let's keep going. For those of you who have joined the stream, we are giving away the 200K celebration boxes that include the unicorn color tumbler, that include my favorite little gavel squishy, and come in this beautiful, beautiful box with the Law Nerds with some other goodies inside. So for those of you that have not seen everything in these boxes, you will be surprised. There's some delightful stuff in this. So with that, yay, 200K box. I will also be doing giveaways of these on Instagram at the Emily D. Baker. If you don't already follow me on Instagram, you can follow me there. And we will be doing a few more of these on Thursday. Members got early access to the boxes and the giveaway. If you want to be a member, if you're here on YouTube, you can go and join the channel. You'll get the little icon. You don't get slow-moded, all of that. If you want the I Have Thoughts podcast and some other exclusive opportunities, that's on Patreon. A lot of you do both, and I appreciate you. So memberships start at just $3 wherever you want to join. We have our members only live stream tomorrow night. Law Nerds, we have it tomorrow night. So you can go to lawnerdsunite.com. Don't forget to do the YouTube things. Let's get back to this hearing. And I might pop over and give away some memberships right now. So some of you can join us in the members only live stream tomorrow. Let's continue.
And they go and take it to the partners. And they're like, oh my God, he's been stealing from us. He's been stealing from clients. And they eventually confront him, and he resigns. That's September 3rd. September 4th.
Everything unwinds.
His best friend, who he had convinced to send back those fees to PMPED, but to cover $192,000 with his own money that Alec couldn't borrow enough to pay, is trying to get a hold of him. And finally gets to meet with him.
The money.
On the doorstep.
The money.
Or on the front porch of Alec's mother's house. And Alec confesses to him that he's been using pills and that he's been stealing, and he doesn't have the $192,000. And all that accountability is starting to crash down on Alec again. And what happens? Within a couple of hours of that conversation with his best friend confronting him about the $192,000, Alec is the victim on the side of the road. And instantly, everybody rallies to his aid again. Accountability is coming on him.
what they're talking about, the victim on the side of the road, he has been accused in a separate case. Well, he's acquiesced. I don't know if he's pled yet, but he confessed. He hired someone in a suicide for hire plot. He hired someone to take him out on the side of the road, and it did not succeed. That was supposed to get a $10 million life insurance judgment to his surviving son and kind of be the end of all of this. But now the person he hired to kill him is pending trial on that. Charges are pending. I believe, I don't think he pled yet, but he confessed to that, to hiring this individual to kill him for the insurance fraud. So, yep. Let us continue. I did that badly.
Suddenly, there's a gunshot, and he's a victim again. And everybody rushes to his aid again, except this time, it doesn't take long for people to figure out that something's not right here. But the symmetry there is very, very telling. Your Honor, this is an unbroken chain of financial crimes that highlight what has happened here. This is a white-collar case that culminated in murders, and we've cited a number of cases in here.
They want to bring this all in trial.
Circumstances in which courts have
No, it's very
admitted evidence
sad.
motive just like this. And I would actually point to one case that we cited, and this is the Siegel case. And this was written, I believe, by Judge Traxler on the Fourth Circuit. And there's a number of cases that we cited in our brief.
So they are
And
arguing
this is a quote from that particular case.
to let this come in.
Because Siegel had been defrauding multiple victims for the last at least 20 years and had never taken such extreme action, it is particularly important for the government to be able to explain to the jury why it was suddenly necessary for Siegel to resort to murder.
This is a lot. This is a lot for a pretrial motion, but they need to get the motive in. A jury is going to want to understand. Just imagine you're sitting in trial on this jury. What you're going to want to know is, how does a father kill his son and wife? Why? Why does this family that seemingly has everything crumble like this? The jury is going to want to know. They need to have a motive. This is the prosecution's theory of motive. They need all of this ancillary information that would generally be irrelevant to whether Alec Murdaugh is the person who committed these murders to come in to explain motive. So they want to use the motive to kind of shoehorn in all the rest of this evidence, because otherwise it would not be allowed in this criminal trial. Those are other acts that aren't going to come in. But if it's the motive, you have to let the jury understand. So let us continue. Congratulations to everyone who got
This is
memberships.
not propensity evidence.
Join me tomorrow night for Members
Evidence
Live.
of all this fraud and abuse of his law license is not propensity evidence. It doesn't show that he's more
It's a
likely
lot of cases.
to engage in fraud, because murder is a much different thing than fraud.
Yes.
But what it does show is what may be the most important fact in this entire case,
Motive?
and that is why this particular individual would murder.
I think the judge is stifling a yawn. Oh, I just said that.
And the answer is because it allowed him to escape the accountability that was coming upon him that he's never had to deal with in his entire life.
Okay.
Never had to deal with it in his entire life. And it worked. It worked. And if it wasn't for that check showing up in September, it might be still working to this day.
Wow.
I think the case law is clear, Your Honor.
The judge is like,
that
all right.
This is admissible evidence. In this particular case, because of how important motive is, and how singularly important it is to the jury.
It is.
Particularly when you have an individual accused of killing his own family members, where there's typically an affectionate relationship. The probative value far outweighs any prejudicial effect. And I would also point
There's
out
the legal argument.
that all of this is established by more than clear and convincing evidence, which is part of the standard as well. All of this, the vast majority of it, is the subject of state grand jury indictments, the subject of evidence that's been gathered by subpoena, sworn testimony, and it's already out there in all of these indictments. So the prejudicial effect is minimal, but the probative value
Is outweighed.
extreme in explaining what led this to happen. And that was that the day of reckoning was upon him.
I think they're going to use
He
that
was
day of reckoning
out
language in
of cards
trial.
to play after he's been playing every card he could for 10 years. Thank you, Judge.
Mr. Griffin?
Vern, yes,
Yeah,
they
Your
are
Honor.
different.
I thought we were going to argue these motions in the order that they were filed. I filed our motion for bill of particulars, but I didn't interrupt Mr. Waters.
I thought they were talking about the bill of particulars too, but he started talking about what he said was, I don't think they deserve a bill of particulars. And then he launched into the other stuff. So it's appropriate shade to say, I thought we were just doing the bill of particulars. What is happening? What is happening? So I saw somebody who just said that they just learned about this in their evidence class. This case or the underlying cases? Because in evidence, I would be talking about this case all day long. So Shula said, just learned about this in my evidence class. Oh, 404B or 404 evidence is what we're talking about. Yes, this is a great example of evidence. I wish we had more televised cases when I was in law school because it's great to watch it in action. It's so easy to read about it and then be like, but how does this work in practicality? Here's a great example of how 404 evidence may or may not work. We'll see what the judge does. But Day of Reckoning is absolutely, I think, going to be a theme of the prosecutor's case. They've said it like 4 times. And it's interesting because we're getting kind of a preview of how these attorneys are going to operate at trial.
Because, frankly, the things that he was saying really conformed to our request for a bill of particulars. And the reason that we had asked for a bill of particulars is because, as Your Honor knows, that character evidence, evidence of bad acts, other criminal conduct is not admissible in a criminal trial to prove that the person is a bad person, that the person is a criminal,
That's
that the
separate
person
from
probably
motive.
committed this crime because of his bad character
It's a good
and
argument.
his bad behavior.
But
And,
motive. But
Your
motive.
Honor, the first 10 minutes of Mr. Waters' argument and the first page of his memo
Right?
goes to exactly that.
No, it
The
doesn't.
first page of his memo says, to properly evaluate motive, the jury will need to understand the distinction between who Alex Murdaugh appeared to be to the outside world, a successful lawyer and scion of the most prominent family in the region, and who he was in real life. Only he fully knew an alleged crooked lawyer and drug user who borrowed money and stole wherever he could to stay afloat. He's a bad guy, Judge. Jury needs to know he's a bad dude.
Why is this dude smiling so
And
much?
because he's a bad dude, we wouldn't put it past him to kill his wife and son.
They're arguing motive. Like, why would they're not arguing he's a bad dude? First of all, the fact that they're saying dude in South Carolina instead of guy has me sent. They're not arguing he's bad. They're arguing why would someone who seems like an upstanding pillar of the community do this? Well, let me tell you everything else to this story so you can understand why someone who doesn't seem like a bad dude would do this. It's the opposite. They're arguing the opposite. Bruh.
And that is the
I like that he read the-
exact reason that we have
I like that he read the
404B
ruling.
in our rules of evidence. In South Carolina, we're lucky that we have the seminal case of State v. Lyle that is cited all around the country. And it's
one of the other lawyers.
Precursor to the federal rule 404B and our rules of 404B.
I mean, y'all have enough
And I
palm
just
trees
would
to
like
say dude. It
to
just,
quote a little bit from State v. Lyle, and it points to the reason that this character evidence of other criminal conduct is not admissible generally. And it
Oh
says
my
the
God.
proof that the defendant has been guilty of another crime
We know what
equally heinous
404
prompts
is.
To
It's,
a ready acceptance of and belief in the prosecution's
we don't need an
theory
evidence lesson.
that he is guilty of the crime charged. Its effect is to predispose the mind of the juror to believe that the prisoner guilty and thus effectively strips him of the presumption of innocence. Now, the State v. Lyle and our rules have developed.
He doesn't
there
need to
are
seem young and
exceptions. One
relatable to
is
this
both.
judge. This judge is like, okay.
State v. Lyle is very instructive on the level of proof you have to make to get to the exception. And I'll just quote, the acid test to get to the exception
Wait, it's not a palm tree?
is
It's
its
a grass?
logical relevancy
Rob.
to the particular accepted purpose or purposes for which it's sought to be introduced. Lyle goes on to say, the dangerous tendency and misleading probative
This is
force
all
of
for the
this class
TV.
of evidence of other crimes
And the prosecutor had his moment
require
too.
that its admission be subject to the courts to rigid scrutiny. And
It's gonna be a long
and
trial.
Concluding in Lyle, it says, hence, if the court does not clearly perceive the connection between
Fair.
the extraneous criminal transaction and the crime charge, that is its logical relevancy.
Oh, the Southern
accused
accents
should
and the
be
closed
given
caption
the
can't
benefit
work.
of the doubt, and the evidence should be rejected. That's State v. Lyle. And so, Your Honor, in their response to our motion for bill of particulars, they say, we've known all of this since, we had it available since January of 2022, that
I should just stop. Bill of particulars, the prosecution did argue bill of particulars. The prosecution said that's not the procedural remedy here. Bill of particulars is often something we see in federal criminal cases. It's asking for a more particular rundown of what the person is being charged with, essentially saying, hey, we can't defend this case because we don't even know what you're charging. It's something that you see more commonly in like white collar cases. I went through all the bill of particulars arguments in the Jen Shaw case. Like, you're alleging I committed fraud for like 12 years, but like, what specifically are you proving that I did so I can defend? Because that's like a long period of time. So you see a bill of particulars, especially when we looked at like the SBF FTX indictment this morning. The indictment was like, you committed wire fraud by lying. You conspired to commit wire fraud by getting together with someone else and lying. It doesn't have a ton of details, but that's where you would see a bill of particulars. In a murder case, the allegation is you murdered this person. That's what we're charging you with. Murder. You don't need a bill of particulars because the charges are pretty clear. We're saying that you killed this person. This person is no longer alive. We're saying that you did it. So I don't think they're going to get the bill of particulars, but let's keep going.
been charged in 18 indictments, over 90 separate counts, and we've been given discovery on that.
Just so you caught that, Alec Murdaugh has been charged in 19 indictments of 90 separate counts. That's not what's going on in this case. There's just the indictments with regard to the homicides and the guns. That's all that's alleged in this case.
And all that is true. And we have all that. And it's a universe of information, and he gave a great opening, closing, whatever argument he wants to give to the jury to point and paint Mr. Murdaugh as a bad guy. But
Motive.
the most important part of our motion for bill of particulars was to identify
Exactly,
that
Rachel.
universe of evidence you intend to offer at trial, and how is it relevant? What is
He
it?
just told
How
you.
does it meet the acid test of logical relevancy to the particular exception here motive?
What page is that in?
Thank you, Your Honor.
On my motion,
You guys have just a minute more to get your entries in. Hashtag
well,
trial
I'm
for the giveaway.
responding to his,
And
his
then we're
argument, Your Honor,
gonna
in our
pull a
motion
winner
bill of
for our last winner
particulars.
today in just a minute. Oh, good. He's looking for stuff.
I thought you were citing from your motion that you're,
The judge is
No,
like,
sir. I was not, I was reading from State v. Lyle about the acid test.
well, why?
The,
If you were reading from State v. Lyle, why the fuck wasn't it in your motion is what the judge wants to know. So finish up getting your
but
entries in.
We did ask in the bill of particulars to tell us what your motive is, what your theory of motive is.
He just told you.
And they have a 20,
isn't that what he just did?
He did. And we're
Now you know.
frankly satisfied with that. We've gotten what we
If
want.
you don't know, now
what
you
he
know.
did last
If you don't
like,
know,
well,
now you know.
Wednesday night at 11:55, he sent us an unfiled response and his own motion in limine asking for this court to rule that all of that universe of information is admissible. And frankly, Your Honor, we haven't
what
had
he's
an
arguing.
opportunity to fully respond to that. I'm here to respond to his arguments on that.
Yes, it's
but we
open
would
internationally,
like
Charlie.
an opportunity
Instagram
to
won't
fully
be, but the
brief
YouTube is.
what they have.
Because I love y'all.
Their motion that they filed and we got yesterday.
And I understand that, as I indicated, we would take the motions in the order filed, and the motion for bill of particulars was a second motion filed, I believe.
The
Mr.
judge is like, he's right.
Waters started arguing number 4, which is his motion to eliminate.
Right.
And it's all combined now with your motion for bill of particulars.
The judge is like, why can't y'all just
Are
pay
you
attention?
still, what do you want me to do with this
Wait,
motion for bill of particulars?
Your Honor, we're satisfied if his response is, that's what they intend to introduce, and
I
that's
just
their
told
theory
you.
of motive, and he puts it on the record. We're satisfied with our bill of particulars.
The prosecution doesn't have to, it has to give you all of the discovery, but it doesn't have to tip its hand and say, this is exactly what I'm arguing. So the judge is trying to keep them going in order, but all the attorneys are kind of all over the place. Let's go and finish our giveaway here. We've got over 2,000 entries, and I'm going to go ahead and pick a winner. The giveaway terms are down below. You have to be willing to be contacted by email. Yes, it's open international. Yes, I will be drawing more on Instagram this week at Emily D. Baker, or the Emily D. Baker over on Insta. And you have to email us with your YouTube handle and your channel link so that we can verify that you are the winner. But it's the law nerd community. I don't expect somebody's going to pretend that they are the winner when they are not. So thank you very much. Let us go and pick our final winner for today. We will do more of this on Thursday. Let's go. Good luck, law nerds. May the odds be ever in your favor. Going through over 2,000 entries at the moment. Winner is Cell. Congratulations, Cell. Yay. Go ahead and email us at help@theemilydbaker. No, wrong. help@emilydbaker.com. I need to go buy the Emily D. Baker. I think I already did. help@emilydbaker.com with those items. There's more in the description. Congratulations, Cell. I can't wait to send these your way. So go send that information. Then we'll ask for your address and get these shipped out to you. Let us get back to this trial. So they want the bill of particulars. They want to lock in the government. This is exactly what they're arguing. The government might change their mind and argue more or different. As long as the defense has the information, the government can change their mind. So let us continue on with this. Yay.
Because we have asked, and now we have heard what the connection is, what their theory of motive is. And I'm happy to
The judge is like, all right.
address his arguments.
All right.
And why that theory of motive that's on page 13 to shift focus away from himself and buy additional time.
Speaking of shifting
to
focus.
try and prevent financial crimes from being uncovered, how that's unprecedented. There's never a case you would find that says that is the logical, that meets the acid test of logical relevancy. So what
Let me
Challenge.
address your motion for bill of particulars.
Yes, bill of particulars. Let's get a ruling.
When I started practicing law 48 years ago now,
Your Honor.
in the state of Ohio, it's
Stop.
routine to file a motion for bill of particulars. Every defendant would file that routinely, and the state had to file a response. That's Ohio. Now South Carolina, and in the state's response,
I started practicing 48 years ago, Your Honor.
that's not a
Thing.
motion that's recognized by this state. You agree with that?
It's not standard, Your Honor. I think the court has
The judge is like, let me tell you that I've been practicing law longer than anyone in this room, except maybe Dick Harpootlian. But here's what the judge just said. Look, this is not a motion recognized by the state of South Carolina. Literally, she doesn't even go here. And the judge was like, do you acknowledge that? And he's like, well, it's not regularly done. No. This isn't it's not regularly done. What this is this is not a thing. She doesn't even go here. The judge is like, I have been practicing law for 48 years. And what you can't do in South Carolina is what the fuck you're trying to do, which is why the prosecution was like, that's not a thing, and then moved into their next argument. It's not that it's not standard, it's that you can't.
The authority to order it.
So this will be denied.
Cited some cases from maybe 1830 or back in slavery time and beyond.
Get it, Your Honor.
But it's not a motion that is recognized.
Don't cite me
under
cases to
current
1830.
South Carolina jurisprudence. Now, in response, the state has
Correct.
outlined what they would like to offer as far as evidence in support of motive in response to your motion for bill of particulars. Having responded in the manner the state has, then it renders
he mentioned it
the motion
all.
for bill of particulars
Oh, he said it all.
the motion. So I want the record to be clear. I am not trying to set a precedent.
This is not
in
lawful
South
law.
Carolina for lawyers in every case to file a motion for bill of particulars because it's not
In fact,
recognized
don't.
under South Carolina law. So I'm not. So you are in effect.
I'm not trying to have you all
moving
start to do
motion
this.
to be
Don't.
And based on the state's response. So that deals in effect with the motion number 2, not necessarily with Mr. Waters' counter motion, which he included in response to your motion for bill of particulars.
Yes.
Yeah, the closed captioning
That
cannot
takes
deal with
care
the
of it,
accents
too.
in South Carolina. I love
Well,
them.
Mr. Harpootlian combined, the first motion was for the motion about the shirt. Second motion was motion to compel a
Okay.
discovery. The third motion was
I like this judge, too.
motion to unshackle Mr. Murdaugh, which he is unshackled here in the
Yes.
courtroom, and we appreciate that. I think that's,
Is there anything else we need to address on that issue?
no, Your Honor.
Your Honor, just for clarity of the
No.
record, obviously, we filed a response. I'm well aware of the case law out there, and I'm not going to, spike this case with an appellate issue, which generally says that a defendant should not be shackled in front of the jury. As always, if specific security issues arise that are expressed to me by law enforcement.
Thank you.
Or the SLED agents responsible for his security, I will, of course, make that aware to the court for a decision at that time.
No, this is pretrial.
All right, well,
This is
defensive.
how the
Certainly
sausage
done
is
a lot of
made.
research and cited my own case, 2008 or whatever year that was, addressing the issue of defendants not being shackled, and that was a death penalty case.
You cited my own case to
Defendants
me.
generally just are not shackled or should never be shackled in the presence of the jury. This motion goes beyond that to address not solely before a jury, but before the media, in effect.
This is allowing
I
Murdaugh to
agree
be in
that,
court unshackled and
motion
in
to
street
the
clothes,
extent
not
that
in
the
jail
defendant should not
jumpers.
be put in a position
I'm running out of
where
paper.
he visibly appears to be shackled, that could be projected out to potential jurors in this case. And I've sent word to law enforcement that they need to address that issue so that that appearance won't be given. So that issue is being addressed.
Thank you, Your Honor.
Most
That motion.
Most
Yes, sir.
murder defendants, by the way, not a lot of murder defendants are unshackled at their pretrial and post-trial hearings, just outside the presence of the jury. This judge made a distinction saying, look, he is in the presence of the media. So we are mindful of him being unshackled because of the presence of the media. Different than like in the Darrell Brooks case where you saw without the jury, he was not visibly shackled. It was shackled underneath the table. The table had a cloth around it so the jury couldn't see. but when he came into court, when the jury was not there, he was shackled with his wrist bound through his waist and then his feet. Alec Murdaugh has shown up shackled that way at other hearings, but is now being allowed to come to court not in a county jumpsuit or a jail jumpsuit and not in shackles. So the court is making it clear that he's allowed to do this for the media, and there's a reason. So that's why he is not shackled for this hearing, and won't be shackled for these hearings. That's a decision made with the sheriffs. I don't think the sheriffs are worried about him attacking someone in the courtroom or having an outburst or something like that. I don't think they have those types of safety concerns in this case.
Then the fourth motion would be their counter motion to our bill of particulars that, Your Honor, we just frankly got yesterday. He's argued it. I would like to respond to his argument, but we would like an opportunity to further brief it since we just got it yesterday.
Mr. Waters.
Thank you, Your Honor. Very quickly, in response to some of the presentation from Mr. Griffin, he talks about the acid test.
Your Honor, I haven't finished. I've not finished my response.
The question is, should you need
Yana,
a
I'm
response,
not
should
done.
you have an opportunity to digest it, research it, and prepare a complete response? And of course, the other question is, a motion, in effect, it's a motion in limine by the state for me to order evidence to be admissible,
Yes, Your Honor.
which is sort of the reverse from the way motions in limine are typically utilized. It's generally to exclude evidence, not to include evidence. Right, you need time to respond to that, and that's certainly understandable. It came in late yesterday.
And Your Honor, again, I would just say that when we just talked Friday, when you were in with the jury, that was kind of what we discussed. They were going to file the bill of particulars, I'd respond, and then we were asked for this hearing here today. So that was my understanding as we were here to argue on that. That's fine if they need some more time. I would, though,
He probably
like
doesn't care.
to have a quick opportunity to respond at the appropriate time to some of the points that he just made, very briefly.
Okay, sure.
If I could, just 5 minutes, Your Honor. Maybe 7 minutes. We'll see.
The point in the
The,
chat that the judge sounds like
but
Donald
the-
Sutherland is well taken.
On page 13, they do identify their theory of motive, which is essentially he's trying to shift focus away from a potential financial investigation to himself. So therefore, he murders his wife and son.
That's the judge's
to
judicial assistant.
Avoid scrutiny and
Research.
puts himself in the middle of a murder investigation. As the person who finds the victims of murder. And as SLED will say, and they've said over and over, when you investigate murders, you start from a circle and you work your way out.
He's nodding along,
Their
just
theory
like,
is to take himself
interesting.
away from being scrutinized in financial misdealings, he puts himself in the middle of a murder investigation. The case law.
I don't think he thinks he thought he would be
dealing with
investigated for murder.
admissible, evidence pertaining to financial crimes and a murder fall into a couple of categories. One is, and really it comes down to 2 points. One,
Julie, this is a great point. They don't want to argue this at trial. They need to argue this pre-trial because they're trying to keep all of that motive evidence out. They need this decided before trial because they need to know what they're up against. So who's keeping track of the timer? Nobody. The judge hasn't put them on a limit. They're not in the presence of the jury. The judge has set aside time for this. He's letting them go. So let's keep going.
they either kill the victim to avoid the victim disclosing their misconduct. Either the victim is the victim of the financial crime itself, or the victim is a witness or has some other ability to
That's fair.
alert law enforcement or authorities of these
Yes,
financial crimes.
this judge is
That's
going to be
number one.
presiding over the trial.
And the Stiegel case, Your Honor,
I'm
that
excited
you
for it,
cited,
actually. I like this judge.
He is a federal,
Spell that word for me so we can.
I'm sorry, Siegel, S-I-E-G-E-L. That's at 536 F 3rd 306. This is Fourth Circuit opinion. And the defendant in the Siegel case was charged with violating Title 18 United States Code, Section 1512.
So federal case.
Which requires the government prove not only the defendant killed the victim, but killed the victim for purposes of preventing him or anyone else from providing law enforcement with information about federal crimes. And so the federal crimes in the Siegel case were the financial crimes. And so that falls squarely within a logical.
So he's trying to distinguish that
motive,
case.
why it's relevant and why it would meet the acid test.
You're boring the sheriffs.
Other grounds is if the murdering of the victim, it causes a financial windfall or benefit to the defendant, so that the defendant can gain money in order to work himself or herself out of the financial predicament they're in.
So are you're distinguishing that from the
Yes.
state's theory and
It's my intention to
allegations in
cover
this
it
case?
day to day.
Yes, I'm telling you, Your Honor, the case law they cited, case law that we've looked at and that we submit to the court, those are the two cabins of motive evidence in murder cases where you get financial crimes in. It's either by killing the victim, they get a financial windfall, or by killing the victim, they prevent the victim from reporting their financial crimes.
Wow.
And what we don't have here in this case, Your Honor, there's no evidence that Alec Murdaugh would have reaped any financial benefit from murdering Paul and Maggie. There's no evidence of any life insurance, no evidence of any life insurance whatsoever.
That's not-
no evidence of anything like that. There's no
They're trying to
evidence that
distinguish it.
Maggie or Paul knew of any alleged financial improprieties involving Alec. They don't put it in here, and frankly, it does not exist in any of the terabytes of information we've received. You know, we've read in the press over years that Maggie had hired a forensic accountant. Didn't happen. No evidence of it. It's not in the case that Maggie and Alec were having marital problems, and that there was an impending divorce, and that would have disclosed his financial house of cards. Not true, didn't happen, not in the case. And there's no evidence whatsoever that Maggie and Paul were a risk to Alec to disclose anything relating to any financial
I don't know if that's going to fly.
misdeeds. Then there's this issue of he did it to engender sympathy and to distract. And as Your Honor, and he said on June 7th, Randolph Murdaugh, his father, was put back in the hospital to die, who did die 2 days later.
That's where he said he
If
was
this was about
in the 911
sympathy,
call.
He had all the sympathy coming to him from the firm and the community, losing his father. So there's really no logical relevance that meets the acid test that this court has to determine. Does it meet the acid test that it is, it's logically relevant? I mean, there's just no case law to support it. We would certainly, we would certainly further brief that. There's other points that he made I'd like to address. First
Okay.
is there's a day of reckoning coming on June 10th because there's a motion to compel in the voting action case, as Your Honor knows, experienced civil trial judge as well as criminal trial judge. That motion was to get Mr. Murdaugh's financial information for purposes of punitive damages. And the extent of what would have been ordered in a practical, in most every case, is a financial statement. And in fact, the evidence is that Mr. Murdaugh had handwritten out a financial statement for purposes of that hearing. All he had to do was produce a financial statement, Your Honor, a statement of net worth. And as Your Honor knows, that there's no doomsday reckoning in that
He was saying he
regard
could have
in a
just
civil
kept
case.
lying? Is that the argument? Is the argument he could have kept lying at this
The other issue that
point?
he raises,
Okay.
the state grand jury is issuing subpoenas for public corruption or something in connection with the voting accident case. There's no evidence that Alec Murdaugh.
The acid test he keeps mentioning is the test that the case law he's citing has set up. So he's saying the case law says these are the factors to consider. This is kind of the acid test of it. So that's why he's saying it. And that's why he's saying it over and over. So anyway, that.
Murdaugh knew of those subpoenas. No evidence. I don't even know if we've been provided those subpoenas, Your Honor. So, I mean, they're throwing something out there without any connection. And then, Your Honor, and that's, you can't, and part of our bill of particulars.
Yeah, they're
was
saying he
asking
could have just
for,
handwritten it.
what
could have just
specific
handwritten
evidence
it.
do you intend to introduce? And his answer is everything, everything. Well, and so it's not an all or
I am
nothing
too.
proposition either, Your Honor.
You just argued it was.
He was confronted as the evidence that they intend to present on June 7th by a bookkeeper in the law firm about where's this fee money? This was fee money. This wasn't client.
Oh yeah, this is going to be a longer trial than they
summer proceed
think.
money. It wasn't lien money that should go to a third-party healthcare provider. This was attorney's fee within the firm. And he was questioned about that. He got a call that his father was going back into the hospital.
Yes.
And so they want to
Jim Griffin,
bootstrap that
The
one
defense attorney, there's two
conversation
main defense attorneys.
into introducing evidence
That's
of
why he's
20
standing
years of
on this
financial
side.
fraud, a chain of events, a hamster on a wheel, of financial fraud, because he had one conversation.
A day
about
of
one
reckoning, you
transaction.
missed one.
And Your Honor, that is certainly, if the court is going to allow anything relating to that, it should be limited to that, not open the door.
Yes,
for
he was
20
gonna-
years of
he was gonna
alleged
pledge his financial
irregularities.
statement.
And then, lastly, Your Honor, the shooting on the side of the road, this happened after the murder. And, they filed in their motion, they've asked that you go ahead and rule that is admissible in this case at trial.
He did
But
admit
his
to it.
explanation of the shooting on the side of the road is he was distraught over being confronted
Yes.
by the law firm over financial misdealings. He resigned from the law firm that day, and the shooting was in relation to his exposure by the law firm
Distraughtness.
of alleged financial irregularities. And it happened after the murder, had nothing to do with the murder. And
He hired someone to take him out for insurance fraud because he was so distraught over the financial crimes, not because he thought he was being investigated for murder. That is what the argument here. He's trying to distinguish the two. Wait, is Griffin a politician or Harpootlian or both? The lead attorney is a senator. That I knew, but I didn't know if if Jim Griffin was.
it certainly should not be admissible. So, Your Honor, that's sort of the 30,000-foot view of our argument, and we would follow it up with a brief with case law.
All right, we're going to take a 5-minute break.
Okay, good. I'm going to answer
5-minute
questions.
recess before hearing back from the state. Thank you.
Thank you.
The judge is like, I need a break. This is the judge's research attorney. So you can see that they're taking notes on the computer, pulling up the case law as the attorneys are talking about it. This is the court reporter. This is likely the court clerk here. So this is a 5-minute break. I'm going to turn the volume down and answer questions. We're going to take a look at Alec Murdaugh's just behavior during this break. I'm going to volume it down and answer questions because it looks, and speed this up just a little bit so we can watch while I'm answering questions. So the judge is going to a break. Let's go and answer some of the super chats. Question: is SLED obligated to give communication between themselves to the defense? Generally, yes, they're not work product, so most things will be turned over. You're on trial for murder, man. He's got a big smile. Question: my super chat was missed last night. Apologies. Did you announce when you are going to be on TV? No, I don't have a date yet for the latest thing. There's a few things coming down the pipe. I just don't have a date yet. Excuse me. That was a very quick break. That was a very, very quick break. That didn't feel like a 5-minute break. If y'all are going to watch this trial, hunker down for his attorneys. There's something else. Yeah, we're definitely going to have to hunker down. I'm going to be covering this trial, hopefully day by day. There is a little bit of travel in February.
Thank you, Your Honor. Very briefly, because I understand
I hope I can make it work.
at some point to argue this in more detail, but I did want to respond to some of the contentions from the defense. And
Did you have a
first
favorite
one
judge?
is, and
Yes.
I have the cases, and we've cited them in there. I'm not gonna
And
read them
least
all, but
favorite.
They all very specifically talk about how motive is a specifically, and one of maybe the most specifically recognized exceptions to 404B, and how particularly important it is in a case. And Your Honor, again, we would assert it's especially important in this case. But one thing I didn't mention before that I do want to mention When we talk about the acid test of Lyle, and what that really refers to is that logical connection. And I think I heard Mr. Griffin even say, okay, he's identified the connection. But let's talk about that logical connection. Within 30 seconds of the first deputy who arrived on the scene on the night of June 7th, 2021, Alec Murdaugh said,
I've left.
my son's been involved in this boat case. I know that's what it is.
I would never while I was practicing in
Within
California.
30 seconds of a deputy arriving, starts talking about the boat case.
Oh,
He made it immediately relevant.
hold on. He's talking about the deputies arriving at the murder scene. I'm going to back up. I was reading the chat. I was not paying as full of attention as I would like. All right, let's go. Oh, I went back too far. Hold on.
Return at some point to argue this in more detail, but I did want to respond to some of the contentions from the defense. And, the first one is, and I have the cases, and we've cited them in there. I'm not going to read them all, but they all very specifically talk about.
I went back to regular
how
speed. This is just how
motive
fast
is
he
a
talks.
Specifically, and one of maybe the most specifically recognized exceptions to 404B, and how particularly important it is in a case. And Your Honor, again, we would assert it's especially important in this case. But one thing I didn't mention before that I do want to mention, when we talk about the acid test of Lyle, and what that really refers to is that logical connection. And I think I heard Mr. Griffin even say, okay, he's identified the connection. But let's talk about that logical connection. Within 30 seconds of the first deputy who arrived on the scene on the night of June 7th, 2021, Alec Murdaugh said, my son's been involved in this boat case. I know that's what it is.
Huh.
He, within 30 seconds of a deputy arriving, starts talking about the boat case. He made it immediately relevant. And
Here's
then
the
if you start
thing.
to walk that logical.
Within 30 seconds of the deputies arriving, that's what he's talking about. That's a really, really interesting bit of information. Now, the 911 tape is public. The 911 tape has been on the Murdaugh Murders podcast with Mandy Matney. And you can find it. There's also been investigative reports on YouTube. You can find the 911 tapes. What he says in the 911 tapes, Alec Murdaugh says, is that he gets home and he finds his wife and son by the dog kennels on their very large property. It seems like it's a hunting property, and calls 911. And then what they're saying is within 30 seconds of the deputies getting there, he's like, it must be about this. Not where is the ambulance? It's interesting that they're saying that it's so fast that he's saying it must be about this. So is Murdaugh already trying to say, I know the motive for this, and this is the motive? It's interesting. It's interesting that that's what they're saying his first words to the deputies were.
Connection back. How do you explain what that means? What is the boat case without explaining what the boat case is?
It's a good argument.
And then how do you explain how that can matter to him so much if you don't start walking back what all that means to his
Context.
status and his finances, and more importantly, to uncovering or protecting from being uncovered who he really was? He says in my motion that I just want to show that he's a bad guy. And that's not the case. And the case law is very clear about that, that if it's evidence of motive, the fact that it also shows
That he's a
the
bad
existence
guy.
of another crime does not make it inadmissible if it is valid evidence of motive.
Can you move over just a
He
little? I want
tries
to
to
see the judge better.
distinguish the
Thank you.
cases that we've
His
cited
face is
talking
everything.
about long-standing financial crimes as being the motive for a murder, and said, well, in those cases, he was trying to kill
Witnesses.
the victim of those financial crimes before they just outed the defendant. Well, it's the same thing here, Your Honor. It's just this case is different. This case is unique. This case is more complex.
This case is fucking crazy.
He's still trying to prevent who he really is from being outed. But unlike those cases where you had a specific victim who had been victimized, who was going to testify in court, and you could just kill them, he can't kill everybody.
That's
He
a
can't
fair
kill
argument.
11 years worth of victims. He can't do that. But what he does do is kill his wife and son, who were liabilities
alleging
in
them.
the boat case, and immediately it stops everything. Immediately, it stops
They're
that
alleging
big
that
reckoning.
goes back 10
Immediately,
years.
he no longer has to answer that question about those fees.
So the wife
That
and some
if-
were
If it failed
liabilities,
to be
he's
answered, was going to
arguing?
lead the firm to do exactly what they ended up doing 3 months later and uncovering it all. It's the same thing. It's the same thing. It prevents detection. And the reason why, if you look at the first page of my motion, the reason why who he projected to the world and who he really was is not there just to show that he's a bad guy.
To show why
It's there to show
it mattered.
how different those things were and how important they were to him to stop this person from ever being exposed. That's what's important to show, the difference between those two. And how important that was to him, a man who had never faced accountability in his life.
It's an interesting
He had to
argument.
protect that reputation.
The family
Your Honor,
legacy, the reputation,
Another thing that
the
Mr. Griffin
perception.
referred to is some of the language that talks about crimes not being that are equally heinous. And again, I said this point earlier, and I want to come back to that, is that we're talking about a number of financial crimes and a murder, okay? This is not propensity evidence that because of the financial crimes and the murder. There is a logical connection, though, that we've talked about of 11 years of that slow burn finally coming to a head. And that's precisely what these
Yes,
cases
Rhonda.
talk about.
It's
when
wild.
They talk about motive being relevant to show why someone might do something that is foreign to any rational person. And this case has that more than any other I think I've ever seen.
It's
Thank
one
you.
of the wildest cases I've ever seen. It's one of the wildest cases I've ever seen.
Anything further?
No. Let's get some rulings.
Well, the state's response, I see, was filed at 11:52 p.m. on December 7th, or essentially was at that time. It was filed yesterday at 9:10. So very,
late.
very little time for the court or for the defense to review the file.
So
State.
he's gonna put this over. Is that what we're doing?
Certainly, the citation state, United States versus Siegel, which I understand was authored by Judge Traxler,
Yes, sir, Your Honor.
former South Carolina state solicitor and well-respected jurist. We certainly want to review his case among others.
I want to read what he wrote.
Cited, and anything cited by the defense in the response. As I indicated, this is a reverse motion in limine
I mean, it's a motion in limine,
for the court to make a
pretrial determination.
preliminary ruling on the
That evidence can come in.
admissibility of how many years?
10.
Of
About a decade, Your
a
Honor.
decade of acts. So that's, the court proceeds cautiously in all instances regarding motions in limine because of listening to the arguments. But arguments are not evidence, and lawyers don't testify. So all of this will be reviewed and scrutinized by the court, and
Under submission.
appropriate rulings will be made at the appropriate time. Certainly, the defense is entitled to have an opportunity to respond. We'll point out, however, that any ruling on any issue can't be based solely on other cases. Each case
Is unique. Yeah.
And rulings must be fashioned according to the particulars of a certain case, of given cases, not just, we don't expect whatever occurred in Siegel, the rule case of 2008 to be exactly the same facts. Each case had facts, each case generally would be unique. So we look to receive the response by the state, and we'll address those issues later.
All right, so that's being taken under submission
Anything else?
for opportunity to
Nothing from
respond.
the state, no.
Your Honor, when would you like us to respond?
When would you like to respond?
That's
Never,
kind.
But,
Did he say never?
if that's not an option, we are coming up on, you're right.
He said never, but that's not an
Yeah.
option.
The Wednesday before Christmas, 21st?
We got-
That's next week.
No, that's not. Yeah, that's the Wednesday. So that's,
Well, it's the 9th, I'm sorry, so. I'll give something for the 16th.
the 16th, Your Honor? Close of business 16th,
Week from today.
a week from today?
Mr. Waters? How's that sound to you?
That sounds fine, Your Honor.
And Your Honor, if we could email it to you.
Can we e-file? Do they not have e-file?
And the state, with the idea that we can mail it to the clerk of court. It's difficult to get stuff filed down here unless you walk it into the court or
Guess,
mail it.
guess you're not e-filing it.
Nature of it. Since the Supreme Court has seen fit not to have electronic filing for criminal cases.
Huh.
If we could get it to you and to the Attorney General on that day, but
Interesting.
put it in the mail to the clerk's office, I would appreciate it.
No objection from the state as long as we get the content, Your Honor.
That's fair. Anything
And
else?
finally, concerning the proposed order on the motion to compel,
I like all the microphones just set up here on the bar.
proposed order on the granting of the motion to compel.
So we need to share that with the Attorney General before we send it to you, Your Honor, is that correct?
Can send it to me and to the
And
Attorney
Attorney
General
General.
simultaneously, and I will await any comment by the
We can-
Attorney General.
He's going to sign the
We can
motion to
have a meeting
compel,
Wednesday, Your Honor.
which is fine. Those need to be turned over anyway. I mean, it's part of the obligation. I think the judge is just like, fine, just write me the order. I'll make sure it's specifically identified. Fine,
Or
fine,
sooner.
fine.
No later than Wednesday. Keep talking. And Your Honor, when would they respond to our filing? I mean, they've made this motion, we're responding, and then obviously they're going to want to reply. And then maybe we might want to serve rebuttal.
Oh my God. You want a sir rebuttal? You're already like, we want to talk more. Stop it.
It's been a while since you practiced civil law. This would, if we're billing, we'd be doing sir rebuttal.
Stop trying to
Your
be
Honor,
charming.
We
And
certainly
it's not civil.
would
It's a
request,
murder trial.
You know, a week as well, so by close of business or by, on the 23rd. I'm sure my,
Will you wrap it?
the 23rd.
in a box?
They were advising me the office may be closed, but that's not going to stop us from working this,
Clerk's office.
this on the horizon.
Everybody's hoping for the holiday.
One additional issue. It's been pointed out that Mr. Murdaugh's grandfather's portrait hangs in the
Oh, we get to see it.
courtroom. Discussed the issue with the clerk as to whether it should be removed for the purposes of this trial.
Is
Yeah,
it going to
okay.
be noticeable? If there's
To
just
the court's discretion, Your Honor.
a
Those
painting.
clerks are typically in charge of the courthouse and courthouse grounds, and she indicated that she preferred court order to that effect. But there's no objection, so that's,
Nobody objects to the painting coming down.
that will be done. There's
It'll be noticeable,
precedent
though.
for it in the state of Virginia, where the judge ordered removal of portraits for certain trials. So it's not without precedent.
But Your Honor, we consent. We-
California doesn't keep portraits in the courtrooms that I've
Very
ever
good.
seen in
So
any of the
ordered.
courthouses I've ever been in.
Anything further today?
Nothing today, Your Honor.
Nothing from the defendant, Your Honor.
Very well, court will be adjourned.
Thank you, Your Honor.
No, it's not a portrait. It's not a portrait of Alec Murdaugh. It's his grandfather, but the name would be on it. What is What is happening? Where is the gimbal? We need a gimbal. Stop it. It could be unfairly prejudicial leaving the portrait. It could make it seem like there's no way this person would ever do this. I mean, their grandfather's hanging in the courtroom. But it could also be, you know, hey, it could signal to something to the jury. I think the court wants to ensure that there's no issue with could this portrait hanging on the wall cause a problem. I'm going to turn the volume down just oh, and that's it. All right. There we go. That is the end of that. So that was the Alec Murdaugh hearing. We went over that with coverage from Fitz News, FITS News. Fitz News is a smaller outlet, which I think is absolutely incredible. Love giving support to, you know, smaller, more independent media. And I found their coverage always to be really fantastic, really balanced, and, you know, more like news reporting. So that is what you're going to get over on Fitz News. So all of you were like, he's taller than I thought. Alec Murdaugh he seems to be a tall man. Every time I've seen him walking in and out of court vis-a-vis the other attorneys, he seems like he's a fairly tall man. I'm going to answer a few questions and then I have to go do school pickup. You guys are letting me know Kraken is now at 129,000. That's incredible. I sent off a message earlier today. Let me see. My son is texting me again. All right, let me just let him know. He's got a whole bunch of stuff he has to, I don't need to explain to you why I'm picking up my kid from school. Apologies for being like, no, well, this is why we need to do it. So with that, so let me see. Rob, does anybody on the chat, can you DM me contact information if anyone has contact information from Corey so I can forward it along to YouTube? So we can try to expedite the play button. I was just asked while I was streaming in my message with yeah. So if anybody has that contact information, please just DM it to me, or Rob, if anybody in our circle has it, if somebody will just send it to me so I can forward the best contact information for Corey along to the folks at YouTube so they can coordinate getting that information, getting the play button to Corey ASAP. That would be fantastic. Can we see what's going on in the Megan Thee Stallion Tory Lane trial? It is not televised. I need to look at who's reporting on it, because a lot of information I've seen coming out on that case seemed odd to me. So I need to see who's reporting on it to see the information coming out of the courtroom. I don't know if people are in the courtroom. I have not had a chance to look into it. So with that, let us go into a few questions and then I have got to go do school pickup. So poll, do we need a deep dive into the Sam Bankman-Fried SBF FTX case? 71% yes. So we will be doing an episode looking into all of those indictments and then the lawsuits, the like influencer lawsuits with regard to FTX. So let's try. Thank you so much for trying to expedite. I am blessed to have some contacts. And while I don't always do things publicly, I'm not going to reach out to them on Twitter. I try to do things when I have a direct channel of communication with people. I try to do it, because what I don't like to do is put someone on the spot. If unfortunately for some reason the answer would be no, I would hate to put somebody that I trust to ask for something, to put them in a position where they publicly have to say this is not practical for this reason. I don't like that. So I try very hard to make sure that I can, if there's things I can expedite offline, I can. So the thing that I'm going to need to do is connect YouTube to Corey's family so that they can work directly with YouTube to expedite that. I don't want to gatekeep contacts. I just want to pass information along and connect people. Let's see. Regarding Megan Thee Stallion, the opening arguments were scandalous from the defense. Sounded like they might try to shame Megan Thee Stallion. If you look at my breakdown of the case with regard to, if you look at my breakdown of the arguments in the last two trials in LA that we've been covering, the oh my goodness, the Weinstein case and the other one, you will see that that's how the defense acts. The way that defense attorneys argue in court is something that, especially in a more conscientious culture, that kind of shocks the conscience of a lot of us. How can they say that? How can they argue that? That does not meet. If somebody said that on Twitter, everyone would lose their mind. But in court, you are going to see arguments that, thank you, Danny Masterson, my brain had totally stopped. You are going to see arguments that are outside of your expectation of how people perceive the world, because it is their job as defense attorneys, and I'm not defending their arguments, I'm just saying, I'm trying to explain. It is their job as defense attorneys to zealously advocate. What defense attorneys don't always count on is offending the jury. And if they are making arguments, in the Weinstein case, it was that one of the Jane Doe victims could not in fact be a victim. It was consensual because she faked the ending to make the assault stop, and therefore she's not a victim. It was consensual because of this. Those are conversations that y'all would be like, what? Who says that? Defense attorneys. So I am sure the defense attorneys will try to lean into that. That is what they are going to do. You will hear things from defense attorneys and you're like, what? Gross. They have to read their jury and decide if what they argue is going to advocate for their client or offend the jury. Skoda said that shit was gross. It was. But also, I think there is, the court of law kind of tags behind the court of public opinion in a lot of things. The law tags behind contemporary society in a lot of things. And we're going to see that with defense attorneys leaning into tropes that are not just problematic, but leaning into tropes that we're like, that isn't a thing. It's zealous advocacy for their client. I'm not saying that that makes it okay. What I'm saying is it's not unexpected. And defense attorneys regularly attack the victim. If the victim testifies, it can go very badly for the defense. So it depends. And jurors are the one who set the precedent. When a defense attorney loses enough time making those arguments, they're going to go, oh, people don't believe these tropes, these things that I'm leaning into, these stereotypes, whatever it is that you're arguing, these don't work. This jury pool, these individuals in society don't agree with that, don't resonate that, don't believe that, and then they have to change the way that they act. Ginger said, this is why I never press charges. Same for numerous friends of mine. Yes, it is. Amber Heard wants to argue, or Amber Heard's amicus wants to argue, that one of the reasons victims don't come forward is because they're worried about defamation suits. You heard me go on and on about what I thought, and it's not the defamation suits. That was not the biggest thing I was arguing about. It was the court process, personal safety, the financial ability to actually get safe so that you can report things and pursue it, all of that. But being attacked in the court system is one of the things that prosecutors sit down and talk to victims about, because it is not an easy process. It is not a perfect system. It is an adversarial system. And the defendant is taught or treated in an adversarial way. Victims are also treated in an adversarial way. Things they post on social media, things they said, et cetera, et cetera, et cetera. So we see the amicus saying everyone's afraid of defamation suits. It's the last thing most people are afraid of. It's what Amber Heard was afraid of. So, Laura said, no, I was worried about having to relive the whole thing again in front of strangers. Yes, a very, very real thing. A very, very real thing, because it is awful. And as a prosecutor, it's one of the things that was very difficult, but also very important to me in my job was helping people feel safe to tell that story in a courtroom full of strangers, and strangers who are literally sitting there judging every word you say to see if you're lying or not. It's not an easy thing to do. And in last year's ABC The Year that I participated in, I got to talk a little bit about the U.S. gymnast testifying to Congress. And I was tremendously proud that they used part of my statement about the bravery it takes to testify about that kind of trauma at Congress or in court. And it's true. It takes a tremendous amount of bravery and fortitude, and the cost of standing up for justice to victims sometimes is more than they can bear. And so when people are like, why isn't anyone going after this person? It might be too much for the victim to bear. They might just need to heal and move on, because the cost of what was done to them in the crime might be all that they can bear. Some choose to go forward, some don't. But I'm never going to judge anybody for that. So let us answer a few questions, and then I have to scoot. I'm going to get to as many super chats as I can. Here's a few things. 1, members only live stream tomorrow night. I can't wait to see you there. 2, more giveaways on Thursday, and more giveaways over on Instagram at the Emily D. Baker, with multiple ways to win over on Instagram. 3, we will be covering more of the SBF stuff. 4, I'm going to get to a few super chats real quick. So let us move on. So this answers the Tory Lanez Megan Thee Stallion case. I will take a look. Did you watch the OJ trial in law school? I saw it in real time in high school, and then we studied it more when I was a district attorney. This is going to motive. I'm going to try to get to just questions. Questions. How are judges tasked with cases? Is it random? It depends on the courthouse, but yes, it's random. It can be, they sort them like when they're filed, that it's like filing number 1 goes to court 1, filing number 2 goes to court 2, filing number 3 goes to court 3. Sometimes it's by sets, like the first 15 cases filed today goes to this judge. It depends on the courthouse, but yes, it is randomly assigned. And that's why if a judge has a conflict with the case, it goes on the record and the case gets shuffled back into whatever the case matrix is. Do people try to manipulate the case matrix? Yes. Did we see that in the Britney Spears case? Yes. Yes, we did. What's the purpose of this hearing? This feels like a jury argument. Pretrial hearing on motions. Some of them were resolved, some of them weren't. FNAF cats. Said Emily, I don't even care about what the subject is. I can listen to you all day. Thank you. I do talk a lot. I love how you talk to us like we're out for coffee, 1-to-1, and even riled up. This is exactly how I interact with people in my real life. Like, oh my God. And on the phone. Aren't the Murdaughs some kind of legal crime family? I don't think I don't know what you mean by crime family. Aren't the Murdaughs a prominent family in this area? Yes. How are they going to deal with that? Jury questionnaires. It can go both ways, because there can very well be the eat the rich crowd that's like, fuck these people, fuck their family, fuck the 100 years of influence that they've had over this area. There can just as easily be people who are just like, these are upstanding pillars of our community. They stand for all that is right and good. It's a tragedy that they are being persecuted in this way. That is the process of voir dire. Question, do pretrials include the jury? No, they do not. The jury has not been picked yet. We will start this case with voir dire if it's televised. I watched it live on Law and Crime, and it was from a different angle. This looks better. This was from Fitz News. I try not to use Law and Crime. Law and Crime took this hearing down after it was live and put it behind a paywall. Is the Gloria going to be? It is my understanding that Gloria Statterfield has been exhumed to have the investigation into her death proceed. So question, Harpootlian is obnoxious and borderline ineffective, but what do you think? But do you think Alex is stuck with him because he paid a large retainer? I don't think he can hire another attorney at this point, and I don't know that Alex dislikes this attorney. So we will see. These attorneys have to know the judge in the area. Bad dude is actually very Southern terminology. Think more dude like in Dude Ranch, less dude like in Surfer. That's fair. More dude like a hunting lodge. Question, is this case more wild than Brooks? The Brooks case was tragic, but what happened was fairly simple. Brooks drove down a parade route, For whatever reason, he chose to do that. And then he had shenanigans representing himself in the courtroom. This case is a convoluted trail of fraud and murder. So the fact pattern of this case, if a writer took it into a writing session, people would say that's too unrealistic. Louise Lemon asked, will this trial be open to the public? Yes, but I imagine there will be a line to get in, and it will be like Depp v. Heard to get in. This is a small courtroom. So we'll see. Lawn Lumber said all the wires, all the jurisdictions, all the fraud, all the conspiracies, all the laundry, basic shotgun charging document, hopefully for more specifics. The other two documents had better specifics. But yes, this is a typical Fed charging document. We're not going to say very much. So we'll see. Donna said The Rock sent him a message also through Andy at Popcorn Planet. I cried. I saw him hit 100K. It's very exciting. Question unrelated because ADHD. Did you or will you talk about Gonzalez versus Google Supreme Court case? Yes, I did. I don't remember where. It was in a quick bits. I will talk about it more. The charging not the charging documents. The opening brief is in and the amicus are in. So I will do that. EDB, you're thinking of the Miami Heat and they've filed to terminate their contract with the bankruptcy case. Yeah, I bet the Miami Heat doesn't want FTX on their thing anymore. Ashanti said, my sister loves your channel. She's watching right now as she recovers from surgery. Could you give a shout out to Dharma? Dharma, recover well. Your sister loves you. No, your family member loves you. You're the sister. And you are loved. Recover well. There we go. I was reading Sister. Let's see. Do I have any more questions? Okay. We have got to, D said, when you're in a trial, is there a competitive feeling you get back and forth with opposing counsel? It depends on opposing counsel and it depends on the judge. I was always trying to represent my case the best I could. And sometimes that meant not getting feisty with opposing counsel because I wanted the jury to just see them doing the most and me not doing the most. Different than a civil case where there can be a little more snarkiness and grandstanding. When you're the criminal attorney in a murder trial, you have to have some solemnity to the case because it's a big deal and the family members deserve that. So sometimes you let them do their thing, being like they're the defense attorney, just wah, 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 wah. Mike said, I listen to your pods when I sleep. Usually your commentary becomes part of my dreams. I'm sorry. Last night I was listening to your pod and dreamt you and I were walking through Target while you were telling me about the Heard case. That is absolutely something that I would do, as long as there was also Starbucks. And with that, chat, I have got to go. To all our winners, congratulations. I have school pickup. I have got to leave. Thank you so much for being here. A huge thank you to our mods. Members, I will see you tomorrow night. Also, members, keep your notifications on because I will be doing some more behind the scenes podcast recording. There will also be a new podcast episode live tomorrow, doing all of the updates in the Britney Spears case. I will talk to you soon. Thank you for being here. Thank you for being a law nerd. Okay, I've got to go. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.